ఆ కోర్ట్ ఆఫీసర్ గారు గుడ్ మార్నింగ్. వినపడుతుందా నా వాయిస్?
Sir V. Hariharan.
AML in the PC.
What is the matter?
Three senior counsel that regard to the interest revenue. We also wanted to see that the notices have been served upon us.
They will come anyway on the list on Monday. Because today land acquisition are listed, they are not listed. They will appear in the Monday. Jyoti Ishwar Gognani.
In matter, the government has replaced the petitioner's house plot, but the MO is interfering. So frankly, it's actually in civil matter that you 1, 2, 3, 2014 has allowed by this honorable.
28. GP for endowments.
It
It will come again on Monday. Who is Satyanarayan Reddy?
Page mentioned daily list item 30 and 31. Page 4 item 32 to 40. Page 5 item 41 to 52. Page 6 item 53 to 70. Page 7 item 71 to 86.
Yes. Yes, it doesn't reach 230. Yes.
Page 8 item 87 to 95. Page 9 item 96 to 111. Page 10 item 112 to 125. Page 11 item 126 to 140. Page 12 item 141 to 154. Page 13 item 155 to 170. Page 14 item 171 to 186. Page 183
One?
183.
Yes.
In spite of the rejections of the objections, the matter was referred to authority panel. What is the
Counterfile?
they have taken 3 times ballot, they have finally the lordship granted, they have not passed.
Informed other side?
And taken up next thing about adjourned question list. The matters are
Wednesday, Thursday. Yes.
244, 240, 247 connected. 3 and 244.
Yes.
Page 15 item 187 to 199. Page 16 item 200 to 217. Page 17 item 218 to 230. Page 18 item 231 to 245. Page 19 item 246 to 262. Page 20 item 263 to 278. Page 21 item 279 to 294. Page 22 item 295 to 313. Page 23 item 314 to 329.
May I please, my lord? This is Rahul Reddy, my lord. Item 321.
Yes.
My lord, this is the matter, if your lordships recollect, my lord, this is a land reforms tribunal matter where the order was passed against a dead person. My lord, all the persons have already appeared, they have filed wakalat, my lord. It's only a question of whether the person was dead on the date of issuance.
Yes, yes.
Page 24 item 330 to 340.
Man.
Page 25 item 341 to 358. Page 26 item 359 and 360.
Review petition. Yes, yes. We'll see next week. Yes.
Page 27 item 361 to 369. Page 28 item 370 to 379. Motion list item 1 Mohammad Ayub Khan.
Yes.
For inspection, he is posted on the table. The copy is not served on.
Serve papers.
Rejection of the managing committee.
Jamali received papers.
Because it's order passed by the municipal tribunal also, and the order passed by the work board also.
History Abu Akram learned standing council. Hearing for respondent. Respondents wanted to see it's time to get instructions. Tuesday? Tuesday. in the evening. Yes. Yes. Give papers to him.
Item 2 G second.
Yes.
Petition is filed, madam, especially the absence and respondent in the issue notice and It is 24/3/2023, 7/7/2023, and 21/10/2023. Directing the petitioner to vacate the premises within 15 days from date of service of the notice. The petitioner is the owner and possessor of the plot bearing number 54 by a part in survey number 931, 932, and 934 of an extent of 100 square yards.
Yes.
The registered seal deed bearing document number 1656 of 2006. Then he is in possession of the property, and thereafter he applied for municipal building permission, and the Greater Warangal Municipal Corporation granted permission on 20/12/2021 for construction of ground floor and first floor.
Yes.
Accordingly, I have constructed ground floor and first floor. Since then, I am in possession of the house by paying the taxes and other things.
Who appears for respondents?
And I have the standing council for floor. And similarly manner, I have filed another petition. The Honorable Court granted status quo to the page number 49. This relates to plot number 43 by 40. And now, in spite of the reply given by the petitioner pursuant to the notice issued on 7/7/2023, the second respondent on the premise that the petitioners have not attended the inquiry and submitted their explanation. The lordship may kindly see the list of attendance manner which I have produced before along with this document. Petition manner, which is a page number 17 manner. Serial number 10 is my name. I have attended the inquiry to the conductor.
Page number?
30, page number 17. This is the attendance list which it shows that the petitioner and others have attended the inquiry on 31/7/2023 at 11 a.m. Before the second respondent. My name is serial number 10.
Where is the date?
Date is on the email. The statement showing the encroachers attended the summary inquiry inspector of Vakful land attached to so and so Warangal date on 31/7/2023 date at 11 a.m. In complaints to this office notice they issued while file number so and so dated 7/7/2023.
Served papers on the standing council.
Served.
On whom?
That's what you also made.
Somebody, it's not the standing council. Who is Abibuddin?
Endorsement is also there.
That's what saying you should have served papers on Mr. Habibuddin.
Yes, Warangal, Anandkonda related to it.
He should be educated here.
Standing council.
Avunandi, is standing council.
Yes, sir. Information I served the papers on it. They issued it.
He never appeared as the standing council before this court.
For that, it should be pertinent to the moment.
Abu Akram is here. I'll pass it over, inform them. Okay.
3, 4, 5 and after.
Yes, yes.
Item 6. Look at Parvul Pala.
A similar matter was filed earlier.
1812 per count.
What is the number?
Not
3076.
Number చెప్పండి.
30767.
30.
767. Copy of.
Even the is only notice ordered, right? Notice number first along with WP 3076 into 23 on 18 from same
Item 7. K. Venumadhav.
yes.
I have made a representation also. And the income level. To the respondent and represent on 8/7/2023.
My lord, in this matter, I am appearing for R5, my lord. My lord, central government matter, my lord.
Is what? Yes.
My lord, I will get a written instruction, my lord.
How you are concerned with this?
Lordship,
What
Transport.
you want to get instruction? About we. What is that instruction you want to get?
my lord, I am appearing for respond number 5, my lord.
ఏం ఇన్స్ట్రక్షన్ తెప్పించుకోవాలనుకుంటున్నారు మీరు? You are a formal party. You are nothing to do.
Yes, sir. Yes, my lord.
Then what? Why are you?
Your lordship, my presence may be recorded. That's only I am appearing, my lord.
When is the award passed?
Yes, but here your lordship directed, page 39, your lordship kindly, consider page 41.
Now collector passed the order
Yes,
as an arbiter, as an award or
yes,
what?
an arbitrator.
Arbitrator. Then you have remedy against that.
But not at all considered any of them are the material placed before the authority.
See, it is an award now passed.
Award already passed your lordship. Not-
Yes,
but
under the
giving it-
NHAC, you have further remedy.
Lordship kindly consider. For that, by passing, by passing such an award, but the authority has to take into consideration that G7.
National Highways Act. Yes.
G7, your lordship.
Yes.
The competent authority or the arbitrator by determining the amount under subsection 1 or subsection 5, as the case may be, can take into consideration the market value of the land and the date of publication of the notification under section 3A. This is not at all taken into consideration. As on the publication of notification, this is not at all agriculture land. Wherein my adjacent lands but taken into consideration as well as the non-agricultural land and passed the award. Sale deed also I placed. The lordship may kindly see now the order passed by the respond number 3.
No, the remedy against this award order passed under section 7 is only repetition or any other remedy is there?
Respect to submission before your lordship I say respond number 3 not consider any of these considerations. Therefore, Act also doesn't show that any other authority against the police guys. Any other authority.
No appeal to civil court. Yes, OPS. Page number?
Same time, you have the other school and the application for the same notification to consider and enhance the compensation. And deviation to let them dispose of this application.
No, arbitrator passed any order?
That is obviously possible award. Why that is a training spot even. The application for enhancement. Before the arbitrator, district collector.
Yes. What happened?
It was pending. My grievance is only to direct the arbitrator to dispose of the district collector to dispose of the application. For enhanced training, but it is not so. Understand the papers of the GP.
Maybe it must have gone to revenue. Revenue department is shown as first responding.
In the 5 awards. The past award.
Get instructions why matters. Pardon? Yes. Yes. NHI. Why arbitration is not being disposed of is there? Yes, same.
Item 9, Mrs. Regional Office.
May I please, my lords?
Yes.
Yes, my lords, this writ petition is filed, my lords, challenging the endorsement, my lords, passed by the land acquisition officer cum revenue division officer, rejecting my representation, my lords. Wherein I sought to, I requested to change the alignment of the proposed national highway, my lords, from the Gaureli to Valigonda stretch, passing from the Bandaravirala village. It is a new national highway that was proposed by the government of India, my lords. In fact, my lords, the survey number 268, my lords, of this Bandaragirala village, my lords, it was notified as a mining zone by the then government of Andhra Pradesh way back in the year 2004, my lords.
Yes.
There was no state highway or national highway that was passing through that zone because of the mining area. My lords, the proposed national highway was sought to be passing through that area. Therefore, I made representations, my lords, to change to see whether it can be changed. The alignment can be changed, my lords, because of the existing rules of the Pollution Control Board and also the Metallophorous Mines and Regulations rules, my lords, of 1961. In
Yes.
fact, my lords, the revenue divisional officer sought for, my lords, instructions from the executive engineer, and also, my lords, in turn, executive engineer sought for instructions from the assistant director mines and geology. My lord, that report is at page number 61, my lords, the report of the AD, my lords, which shows, my lords, the proposed highway is passing very close to the mining zone, and it will affect the quarrying activity in the mining zone, my lords. But that was not considered by the respond number 5 in the orders, my lords, and it has vaguely rejected my representations, my lord, for seeking to change the alignment. My lords, may kindly see page 63, my lords. The conclusion of the assistant director, in view of the above proposed and
Let them get instructions. Yes.
date, my
Thursday, 16th.
motion list
Yes, yes.
deeply aware.
Item 10 to 15.
All press content, 4 weeks notice.
4 weeks notice. Item 16.
My last item number 13.
Yes.
Last 1.5 years, they are not paying not filing counters. Out
of
Item?
filing counter.
Counter in what?
This is land acquisition case.
Item?
13.
13 contempt case అండి. Case number చెప్పండి.
362691.
ఏంటండి నెంబర్ ఎంతండి? ఐటమ్ నెంబర్ చెప్పండి.
13.
13 39
13 sir.
13 ఏముందండి లిస్ట్ లో?
WP 362691.
Item 16, A. Keshav Reddy.
Sir, please see the list and what is it? Yes.
About the official in this case, I am starting 17. And the plaintiff in the main suit has sued seeking the relief of declaration, recover of portion, the property acquired through our ancestors. All the documents are filed before the lower court, and the defendants have encroached into the land. And then in the 2009, up to filing of the suit, then our names are reflecting. Subsequently, they filed a written statement admitting that we are the legal heirs of this some Rajaya. We are claiming also Rajaya is our father. So subsequently, the trial was commenced, and
What is that amendment now?
stay of the further proceedings.
Stay సంగతి తర్వాతండి. What is the amendment that is sought now?
Amendment, Lordship, now they are saying that even we are not the legal heirs of the Rajaya. That's page number below. ANM 15 to 20.
There is a, that is all a typographical error in the
Entire case, the relief which is brought by as a legal heirs, now they themselves are admitted in the written statement. Even the cross examination also not questioned. Even the evidence also completed.
show me what is that amendment? What is that amendment?
Amendment is saying that we are not the legal heirs. Lordship, page number 16.
Yes.
In pair number 3, it was inadvertently mentioned that the husband of the plaintiff number 1 by name late Guru Raja sold away the scheduled flat. Instead of mentioning Guru Raja sold away the scheduled flat. And another pair in the 15th line of pair number 3 of written statement, it was advertently mentioned that even after the death, the plaintiff being the legal heir, instead of after death of Guru Raja, the plaintiff did not take any steps. And another
And who is the plaintiff number 1?
wife of the Guru Raja.
Then what difference it makes?
Because once they have admitted that they are the legal heirs, legal. Now they are the intention is
No, legal heirs ఎక్కడ legal heirs గురించి ఎక్కడ ఉందండి?
చెప్పారు సార్. The second fifth paragraph. That in 15th line of paragraph 3 of written statement, it was advertently mentioned that even after his death, the plaintiff being the legal heir very clearly admitted as legal heir. The entire defense which is taken is different. The issues, everything will be changed. Even it's coming for different evidence, plaintiff evidence during the course of cross-examination also, the not taken any, so not yet suggested at least to me. So not the legal error of service. The nature of this. No.
Where is the plaint?
Page number 20.
No, they are all shown as wife and sons of Rajaya only.
Yes, ma'am.
Then
Now they are saying that we are not the legal heirs according to their intention.
no, see, but still they are shown as
Children of Rajesh, wife and children of wife. They have also admitted in their written statement we are the legal heirs and we have not taken steps earlier. Their contention. Now, ad hoc suddenly, after the commencement of the trial, even closing of the press, immediately they changed the words.
Please read the order of that court.
It's also wrong. It is here. Here is what is. Just so that we mentioned that.
No, which portion of paragraph 3 is now sought to be amended?
Paragraph 3.
3 లో ఎక్కడండి అది?
It's here. Page number 51. 51. Page number 51. Page number second.
So additional retracement statement.
It is submitted that the husband of defendant number 1 by name date Puraraja so that it is land go register sale page. So by residence here and delivered portion of sharing in the year 1973 and this in one
Any dispute about the relationship?
with that presently the application which is made before the honorable lower court that they are disputing the relationship. So only the person entire my ASM going to
Notice. Petition is permitted to take up. Respondents 1 and 2.
this.
What the filing to observers? Notice on the respondents as well as on the council appearing for the respondents in the suit. Take out notice on respondents and also on the council. Both. 24. Pending for election scheme of ongoing proceedings invoice numbers. Yes.
17. Field group class.
Manager for the contract. There is land acquisition case for that, sir. The petition have 4 acres. Of the 4 acres, they have acquired 3.5 acres, paid 3.5 acres. But they have occupied 4 acres malad without paying single fine. Last 1.5 years, they are dragging the back from the class. Without filing any forms of legal thing. And you pass the appropriate arrangement. Meanwhile, they are going on constructed in building malad. When a private builders malad. Section 8. Should be acquired.
When it was acquired?
Application also malad.
When,
Number 90.
when they acquired?
Page number 24.
ఎప్పుడు ఎక్వైర్ చేశారండి?
Page number 24 land.
చెప్పొచ్చు కదండి పేజ్ నెంబర్.
22 to 2006 malad. Page number 20.
What is there to show that you have remaining land on your name?
They have filed salient numbers. And see the page number 28. 1969 salient.
అవునండి 69 తర్వాత ఇంకేం లేదా మీ పేరుతో?
Page number 28.
అవునండి సేల్ డీడ్ సరే 65 సేల్ డీడ్ తర్వాత ఏముంది రెవెన్యూ రికార్డ్స్ లో ఉందా?
Revenue cards.
Yes, swap years. Counter not filed. Why?
Last 1.5 years they are saying going and saying.
మీరు పేపర్లు ఏమి వేయకుండా ఏంటండి? You don't know what is your case and
No, they are filing this salient.
sale deed is enough 65 sale deed. Yes.
They have given a representation, my lord. So it's just that
Request of
dispose that representation, my lord.
standing counsel appealing.
Item 18. Rajesh Kumar.
Yes.
Problem. Only prosecutor, motion list, my lord. Not reaching.
Sir, your matter is over. You disturb the court proceedings without noticing where your item is listed. And you don't answer the questions posed by the court. No, what did you file to show that the construction is going on?
Filing the
Then what is the use saying without there being anything on record?
filing the started construction. Filing photos, my lord.
Yes.
Instructions were please. In this page number 71, my lord, on basing on a representation, my lord, land compensation for the entire circle number 104 not paid, my lord. And we are the petitioners who have land in 104, 105, my lord. Our name was also notified in the notifications, my lord, where all other people have been paid, but for these petitioners, my lord. Page number 71, for instance, my lord. Before above
Yes,
paragraph, 3 lines.
That's only it is posted. Request of language. 16.
The motion.
Yes, yeah.
Item 19. K. Suresh Babu.
May I please, Your Lordship?
Yes.
Yesterday, Your Lordship, at request of learned assistant government land acquisition posted today, My Lordship.
Yes, GPR.
My prey is limited, My Lordship. I am the owner of the said property. Without due process, they are trying to acquire my land, My Lordship, for sake of canal.
Wait. Yes, GPR.
My only submission, My Lordship.
Please wait, sir. Please. State request. Is extended. Yes.
Status quo may be extended, My Lordship.
Item 20.
Yes,
M.
yes.
Paresh Kumar.
Yes.
What is the section 2019 details of which?
Deposited, huh?
Deposited on that 2019, there were disputes between the petitioner and notary. That is the reason why the disputes were going on. We have deposited the amount in the checks in these. Number 3, the instruction along with the letter address to the chief judge also in the last question.
Yes, what do you say?
They are involving the introduction to direct
You have to go adduce evidence whether you are entitled for compensation or not, whether in the LAOP. And then you can seek. Going to copy, give her. Get instructions, stop, password. Password. Your presence may not be required. Instructions తెప్పించుకోండి ఎందుకు మళ్ళీ అక్కడ it is submitted by standing force for TSHC that in view of dispute for entitlement for the compensation in question, the same was already deposited with the civil court as early as in the year 2019, and a copy of that letter is also placed on record. And counsel for the petitioner seeks time to get instructions and the post on Tuesday, Wednesday name. చెప్పింది వినాలి కదండి, మీరు చెప్పింది వినకుండా ఏం చెప్పాను విన్నారా? పోనీ ఒకటి చెప్పింది విన్నారా? పోస్ట్ ఆన్ వెన్స్డే ఏఎంఎల్ అని అంటే మీరు మళ్ళీ మోషన్లు ఇస్తారండి. Yes.
Item 30, 31 and 32. Yeah, Hemant Reddy.
Item
30, 31, 30.
Announcement. Yes. Yes. Yes.
Before lordship was 23 members business large. Set aside the notification dated 8/1/86/2001. Lordship may kindly see the affidavit starts from compilation as affidavit starts from page 1 to 28. Prayer page 20.
Yes.
Petitions before lordship seeking a direction clearing the action of the respondents in acquiring the annexer A properties whereas they have mentioned their entitlement in annexer A, that is 23 plots lot, as well as the notification dated 8/6/2001, declaration published in Form 2A, same dated 8/6/2001, as illegal, arbitrary, and against the fundamental rights of the law. They sought further directions, respondents 1 to 10 not to interfere in the possession and enjoyment of certification houses, parts therein.
But some portion is missing. Where is page 21?
Page 21.
Yes, page 21 continuation ఎక్కడ ఉందండి? Declaration dated 8/6/2001
in Form 5A.
ఇందులో లేదు అది. The top portion is missing. Every page is like that. Yes.
Form A published in AP Gazette as per the list of this document, and also sought a further permission not to differ system from their intent in detail correct. The admitted fact, even the respondent in the counter disputed not is that
And the prayer is amended subsequently.
the amendment of prayer is only to add the 29th respondent. But subsequently, during the pendency of the dispute of these proceedings, this and area was handed over to NGOs. That's why the English petition was amendment petition was filed to amend the
The prayer itself is substituted.
substituted. The prayer was substituted. That's the I'm coming with. This is the initial prayer. Subsequently, an amendment application was filed seeking to set aside the GO issued in favor of the 29th respondent, that is 1033 up to 2003. It was ordered. Now the prayer is to set aside the GOMS number, so 1033, the amended prayer.
What is it? Please read the amended prayer.
So that's amendment petition also filed for 28. Page 78.
Other one prayers, other one amended prayers.
Page 88, is therefore prayed. The Honorable Court may please to amend the prayer petition number 7 unanimous declaring the action of respondents in acquiring petitioner's house plots mentioned in Annex A, filed along with the affidavit so and so Rangari issued arbitrarily and in law set aside the 4-1 notification dated Form 2 potentially and 6th declaration dated 8/6/2001 Form 5 published in the AP Gazette issued by both respondent and direct respondent for the of the land activity proceedings is further direction to the respondent not to interfere with the peaceful question and enjoyment of petitioner's house plots in the area of 6 acres to Gonzales and survey number 7. So the developed layout and set aside this is the UMS 1033 dated 1/10/2002 and pass a charter. This amendment was ordered. So subsequently, the entity in whose favor the land was allotted was also arraigned as respondent number 29. See the amendment.
చూడండి ఒకసారి. The amendment application again. WPMP number 28165 of 2018 20396.
No, understated. I think 10 2008. WPLP 28165 of 2008.
తీసుకోండి.
Separate application by immediate.
Okay, 9201 of 2009. So
You assassinate should also file its counter.
how many amendment applications you filed?
Only one amendment application, one include application.
చూడండి. ఇది ఇవ్వండి. Award already passed in this matter. Award was passed.
Award was passed.
You questioned the award?
Just award was passed on 31/12/2000. Bypassing all the statutory.
Whatever it is, you have to question that award.
Separately, it was not questioned because the award was passed on 31/12/2001. Because when there is a statutory violation, because there is a case law, you need not separately question the award when it was passed in violation of the statute. Clear violation of the statute I will demonstrate. Clear violation.
Sir, without questioning the award, how award will go? You don't question the award, how acquisition will go?
When we are questioning the very notification or declaration which is preceding the award. The very notification and declaration were issued in violation of the statute. When those were award automatically.
Is there any stay?
For some time there is stay. Status quo is ordered. For some time.
Subsequently, no stay.
Subsequently, it was.
Proceedings have taken place.
Proceedings have taken.
Then
proceedings have taken place.
brief kuda chodakanda em lekanda vaste inte.
Because it was filed way back in the.
So tell me, what is that amendment application? Did you file that amendment application or no?
This amendment application was filed by there are 23 applicants. Some of the applicants filed.
Who is the counsel? You are not the counsel. You are not appearing for them.
Now I am appearing at the time of filing.
Who will take that response? 5 petitioners will file one amendment application. Other petitioners will file another amendment application. And what is ultimately the relief in the writ petition as stands now?
The relief as on today stands seeking to settle the notification as well as declaration as well as the GOMS number.
You don't know what is there on record. That is the problem. That's why I gave you the EB, original bundle. Yes, Venugopal.
Yes, well, I'm appearing for the 6th respondent millet in 8406 of 2013. A society consisting of employees millet in whose favor the land was allotted by GO 1033 millet, which is now sought to be set aside as a consequential prayer. In fact, millet, the notifications were under challenge in earlier writ petition. Writ petitions came to be dismissed. They preferred writ appeal. A writ appeal was also dismissed. The very same notification, millet. Thereafter, they preferred SLP. I passed down those orders, millet. You may kindly permit me, millet. I passed the order passed in writ petition as well as writ appeal as confirmed in the special leave petition, millet.
Yes.
WP.
Yes.
22046 of 2002.
Yes.
It is not open to others, millet. Even a prayer is sought, millet, against the notifications. These are to be treated as covered matters by the earlier judgments, millet, on the same notification. If a different prayer has permitted in order in SLP, if it is taken, millet, it would be on different reasons, not for the reasons set out in the writ affidavit. Writ affidavit is challenging the notifications which were already confirmed by the writ court, millet, earlier.
Yes.
In SLP, millet, the limited prayer they sought, millet, whether it binds to the writ petitioners or maybe a different issue, whether they opt to pursue such remedies if available. The Honorable Supreme Court, millet, consciously used the words that if permitted, they can pursue remedies under 24(2). In fact, millet, this 24(2) is thoroughly examined by Honorable 5 judges benches, millet. There are certain issues adjudicated and past orders, millet, giving some guidelines. If the prayer they opt, millet, if does fall within the parameters of the orders of Honorable Supreme Court of 5 judges, millet, then they can pursue the remedy. But the writ petition as such, my lord, against the notifications, it cannot be maintained is my submission. When substantial prayer against the notification is not maintainable, the question of consequentially setting aside the GO, my lord, under which we got the land, it is not maintainable. In fact, my lord, we were initially allotted land elsewhere in exchange, my lord, that is.
Yeah, the only point that is raised is
yes,
application of 4-1 notification as well as 6 declaration on the same day is bad.
This is considered by the Honorable Division Bench, my lord. May I read the relevant portion?
Yes.
Para 8 of Order of Honorable Division Bench, my lord, on next page.
Yes.
On the top, my lord, though it is the case of appellants that a notification under 4-1 and declaration under 6 of the Act were published on the same day. This is the exactly point raised there also, my lord. But however, from the counter of it is clear that notification under section 4.1 of the Act was published on 13/6, whereas declaration under section 6 of the Act was published on 14/6. It is evident from the counter of it that even before filing of the writ petition in the month of October 2002, possession of the lands in question was taken on 2/7/2002 and was handed over to the requisition department. Even after filing of the petition, though the appellant's petitioners have obtained interim orders of status quo for a period of 2 weeks, thereafter they could not seek any extension of orders. And the award was also passed. That is also recorded by Honorable Division Bench, pursuant to the notification and declaration by conducting necessary inquiry. Though it is contended by the Learned Counsel for the appellants that there was no reason to dispense with the inquiry having regard to the purpose for which the land is sought to be acquired, but however, such questions cannot be examined at this belated stage, nearly after 7 years of passing of the award, pursuant to initiation of land acquisition proceedings.
Yes.
Finally, my lord, the order passed by learned single judge against the notifications.
Publication of notification on 13/6 and declaration on 14/6 may be true.
Yes.
But the date of notification under 4.1 as well as declaration is same.
Yeah. No, my lord, it is as per the
publication is a ministerial act.
Yes.
Yes. Once the notifications, both notifications are of the same date, and that is directly contrary to the judgment of the Supreme Court in Radhesham.
But regarding publication, my lord, the Honorable Division Bench made distinction, my lord, that it is on 13/6 notification, 14/6, my lord, 6 publication.
As per the convenience of the press.
But dates.
Date of proceeding is relevant, but not the date on which it is published.
But originally, this notification is on 8/6, my lord.
Both are 8/6. 4.1 as well as declaration are 8/6 only.
But ultimately, publication made on, but the division bench order, my lord, it became final. Now, my lord,
not taken note of the judgment of the Supreme Court in Radhesham. And this court in the other similar matter allowed the writ petitions. That has become final.
But this is in fact confirmed by Honorable Supreme Court also, my lord.
It is not a confirmation. That is not a confirmation.
Will answer each and every point.
What is the prayer in the writ petition? You don't know.
Prayer I'm establishing,
What establishing? What is the prayer in the writ petition stands as on today?
As on today, to set aside the notification as well as declaration.
What you don't know, that's what I'm saying.
Because I'm reading from the prayer itself.
So it is 2002 and
2002, because I'm only relying on the legal.
Yes. Yes, Venugopal.
Yes, my lord, in view of these earlier judgments, my lord,
please tell the court whether this order passed by the Supreme Court amounts to confirming the order passed by the division bench.
Yes, my lord, they have withdrawn it. In fact, my lord, it is argued on merits, my lord. The bench proposed to dismiss it. At that stage, they have withdrawn.
Simple.
Thereby, my lord, the division bench is subsisting.
Unless the Supreme Court assigns reasons.
Yes.
And that doesn't amount to confirming the
it may not be a proposition laid down in the case, but this is nothing but confirming the judgment of division bench. Even otherwise, there is a division bench order, Millard, as such binds the parties here also, Millard.
Yes.
Honorable division bench has considered and took a view that since there is a distinction between two dates, Millard, regarding publication, actual publication, it is
Yes.
taken note.
Yes.
In fact, Millard, initially proposed land to allot to us is elsewhere. In exchange, Millard, this is given. The other land, Millard, initially allotted to us required for public purpose. Now, Millard, it is covered by ORR, Millard, at Gachibowli area. That land was initially allotted to the Employees Society. In exchange, Millard, that was taken for public purpose, and this is ultimately given. Since a long back houses are constructed, they have been residing there, Millard. That was brought to the notice of Honorable Supreme Court also, Millard, showing the photos and the layout sanctions. Everything is placed before the Honorable Supreme Court at the time of hearing about the implementation of that GO and also developments subsequent to it.
Yes. Now petitioners say that they don't want this land to be given back. They are asking for alternate land or initiate a proper acquisition proceedings.
It is for a government has to answer, Millard.
Yes.
They are able to allot alternative land.
You are appearing? Yes, but it's only that legal issue, nothing else.
Yes.
You don't have to go into factual aspects.
Yes. Regarding just now your lordships have put a query regarding the notification date and declaration date is one and the same, 8/6/2001. Hence, it is not valid. Here, this is the 8/6/2001 is not the publication date. It's only an approval date.
Declaration date.
Publication and the declaration. But the publication date is 15th, and there is 1 day difference between, hence it is valid. In view of judgments of 1996, 1 Supreme 562.
1996?
1 Supreme 562. 96 1 ALT 690 division bench.
1990. What is the other one?
1996 volume 1 ALT 690 division bench, and 1991 ALT page 28 simultaneous publication of 41 and 6 not bar.
1999 1 ALD.
Page 28. Here your lordship will find the page number 24. 13th June. There's 1 day gap publication.
Yes, that is 13th and 14th.
Normal, it cannot be done, but in urgency clause, 1 day is valid. This issue has been dealt in case by the Honorable Apex Court, and law has been laid down. 1 day is sufficient, and it does not, and it is a valid notification because the urgency clause has been invoked in this.
Yes.
Even that argument advanced by the government being taken into consideration is still violation of the statute. I'll admit your lordship to the 17 class code. Hold it.
Yes.
17(4). In case of any land.
Yes.
To which, in the opinion of the appropriate government, the provisions of subsection 1 or subsection 2 are applicable. Appropriate government may direct that the provisions of section 5A shall not apply. And if it does so direct, a declaration may be made under section 6 in respect of the land at any time after causing public notice under section 4, subsection 1. So even though as canvassed by the land GP, 5A has been dispensed with mirror, still the declaration is need to be notified under a statute only after publication of the notification under section 4. What is meant by publication? There are 3 modes of publication: gazette publication, publication in newspapers, and publication in conscious places like MRO office and all these things. Even according to them, as per the amended AP Act, they have to declare within 40 days. I'll ask you to kindly invite their counter so that the last date of the publication on section 4 has to be taken as the date of notification, publication of notification. The declaration should publish only after that date. Here, I will invite your lord's attention to the counter filed by the official respondent in the compilation it is there. From 29 to 44.
Yes.
29 to 44 is the respondent.
Yes. Yes.
Page 34. Last portion is the draft notification and draft declaration proposals are submitted to the collector, Rangareddy district for approval. Accordingly, the district collector has approved the draft notification under section 4.1, that is 17.4 of the Land Acquisition Act, and draft declaration on section 6 of the Land Acquisition Act in his proceedings dated so on, 8/6/2001. Both are approved by the collector on 8/6/2001, and the same was published in the AP Gazette Extraordinary on 30/6/2001, so on so on 4/6/2001 respectively. Lordship may believe not, draft notification made in Nizam Telugu Daily 28/7/2001, Bridge English Daily 24/7/2001, draft declaration made in Nizam Telugu Daily on 31/7/2001, Bridge 38/7/2001. The copies of the Gazette along with 9(1) notices were also published at all conscious places as per the provisions of the Land Acquisition Act, inviting the patients so on and so forth. Further, the counter of the respondent number 6 indicated the same 45 to 77.
ఇంకా మళ్ళీ సేమ్ అయితే మళ్ళీ ఎందుకు?
Publication the conscious place was after
Page?
Page 61. Page 61.
Yes.
Have reiterated the Gazette notification. The substance of draft notification was also got published in the locality on 8/10/2001. So 8/10/2001 is the date of publication of notification. The concluding date, my lord, has to be considered as the date of publication of notification, which is being required statutorily under section 4.1. So in the present case, the statute says that the declaration should be published after 8/1/2001 only.
Yes.
It is a clear violation of the statute.
Yes.
Moreover, my lord, just now they have said that question was taken on
You have copies of those judgments, GPM? The citations you have given,
Yes, they thought not that,
give them to Kotak.
HMDA is appearing.
Give those citations to Kotak, sir.
Yes.
Yes.
They have demonstrated in the counter of it, they have taken position on 2/7/2002. Just now, the land clearance council also demonstrated that position was taken on 2/7/2002. The lordship may kindly see this. Another statutory requirement, my lord. Seventeen 5. 17 class 5. In any case,
Yes.
in any case where the state government have directed the subsection 4 that the provisions of the 5A shall not apply. The collector shall take possession of the land within 3 months thereof. The notification, it is a statutory requirement, my lord.
Yes.
The notification and declaration, even as per them, was on 8/6/2001. If they invoke any agency clause, because in this except on paper, there is no notice under section 9, there is no notice under section 10. It is not their case that they serve notices. While dispensing the inquiry, statutory inquiry on section 5A, even giving some credence to them, my lord, even they invoke section 5A will not apply in view of the agency. The statute requires that they have to take position within 3 months. Repeatedly, they have taken this position on 2/7/2000.
Yes.
It is another statutory violation. My humble submission for your lordship, my lord, because the award was passed subsequently. By the time of filing the petitions, the petitions don't know, everything was under wraps, my lord. They have questioned the notifications and declarations on the premise that both were published on the same day. A settled law by the apex court, which even stands good today. Moreover, there is a statutory violation. When the notification and declaration goes, my lord, what remains? The subsequent proceedings will lapse automatically. Any violation of any violation of fundamental rights can be executed, my lord. When it is against a statute, definitely this court has to interfere, and the declaration under any circumstances will stand to scrutiny. In the same relevant circumstances, the adjacent land, same notification, same declaration on the same day was challenged before this honorable court, and that was made part of the record also. It was part of the record, the judgment rendered by this honorable court. Clearly set aside the declaration and giving liberty.
Where is that?
In the compilation, I think. The books also it was there. In the compilation, remember?
February.
184, page 180.
Okay.
This is Gopal Reddy. 184. You start from page 185. The case of the petitions as follows. The petitions are the absolute owners and possessors of agricultural land at land and extent of 30 kilometers east, total atmosphere, 3 acres, 29 meters, in survey number 109, Nanakram Goda village, Sailing Mandal, Rangareddy district. The said land was sought to be acquired by the government for the purpose of development of cyber park for APAC. Accordingly, a notification on section 4(1) of the Act was made on 8/6/2001, and the same was published in the AP Gazette on 13/6/2001. In view of the urgency, the first respondent, by exercising the powers conferred under subsection 4 of section 17 of the Act, dispensed with the inquiry on section 5 of the Act. Accordingly, draft declaration on section 6 of the Act, dated 8/6/2001, was published in the AP Gazette on 14/6/2001. Similar facts. Simultaneously, 4(1) notification and stipulation published in the local newspapers. Within the same, the petitions filed present petition stating dispensing with 5 inquiry is arbitrary, illegal, as petitions are only one is one. The response of the government is similar as being projected in this case, Millard, was recorded. The operative portion, Millard, at page 180. Admittedly, the facts disclosed 4(1) notification and 6 declaration were made on the same day, 8/6/2001, but draft notification on section 4(1) was published on 13/6/2001 and draft declaration on 14/6/2001. The Supreme Court in state of UP versus Rajesh Shyam Nigam categorically held that section 6 declaration has to be made after publication of the notification on section 4(1). The Supreme Court, while interpreting section 17(4) of the Land Acquisition Act 1894, held as follows. It is true that the expression of the date of publication of the notification introduced in section 17(4) can be explained away, making no change from the provisions of law by reading it along with the amendments made in section 4, whereby in different situations in section 4, the last date of publication of the notice has been determined as the date of the publication of the notification, and similarly section 6, the date of the publication of the notice has been provided for. But the words after the date of the publication of the notification in subsection 4 of section 17, that with simplicity clearly indicates that the declaration on section 6 had to be made after the publication of the notification, meaning thereby subsequent to the date of publication of the notification. It appears to us that there is nothing in the scheme of the Act which militates against the construction. At times where emergency provisions are invoked, emergent action may be taken, but in such a situation, in view of the state of law that was before it, the legislature has made a conscious change which cannot be explained away merely because this is the consequence of the changes in section 4 and section 6 of the Act. In view of the authoritative pronouncement of the law declared by the apex court, declaration which was made on 8/6/2001, even before the publication of notification of section 4(1) cannot be sustainable. Accordingly, declaration made on 8/6/2001, which was published in the AP Gazette, proposing to acquire an extent of land belonging to the petitioners is passed.
Yes.
Moreover, my lord, I have compiled a case law volume, my lord. What is meant by doctrine of measure? It is an authoritative judgment doctrine of measure, my lord. 2006 SCC 359.
Yes.
Sorry to interfere, but that is more request. Can I find because I have to go on this? Is the files are being displaced earlier? It was being done by the learned application.
2002 matters.
Yes, only on Tuesday. Monday is
Yes,
the
yes.
day.
Yes, yes.
2006 SCC, my lord. Starts on page 9.
Yes.
Pages paras 27, 40, 44. Paras 27.
Yes.
A petition for leave to appeal to this court may be dismissed by a non-speaking order or by a speaking order. Whatever be the phraseology employed in the order of dismissal, if it is non-speaking order, it does not assign reasons for dismissing the special injunctions. It would neither attract the doctrine of nature so as to stand substituted in place of the order put in issue before it, nor would it be a declaration of law by the Supreme Court under Article 141 of the Constitution, but there is no law which has been declared. If the order of the decision be supported by reasons, then also the doctrine of measure would not be attracted because the jurisdiction exercise was not an appellate jurisdiction but merely discretionary jurisdiction refusing to grant leave for appeal. We have already dealt with this aspect earlier. Still, the reasons stated by the court would not attract applicability of Article 141 of the Constitution. If there is a law declared by the Supreme Court, which obviously will be binding on all the courts and tribunals in India, certainly the parties there. The statement contained in the order, other than on points of law, would be binding on the parties and the court of tribunal, whose order was on the challenge and principles of judicial discipline. This being the apex court of the country, No court or tribunal or parties have liberty of taking canvassing any view contrary to one expressed by this court. The order of Supreme Court would mean that we have declared the law, and in that light, the case was considered not for grant of leave. The declaration of law would be governed by Article 141, but still the case not being one where the leave was granted, the doctrine of measure does not apply. The court sometimes leaves the position of law open, or it sometimes briefly lay down the principles may be contrary to the one laid down by the High Court and yet dismiss the special leave petition. The reasons given are intended for the purpose of Article 141. This is done because the event of merely dismissing the special leave petition, it is likely that an argument would be advanced in the High Court. Supreme Court has to understood that not have been deferred in law with that. Yes, so in Milan, the Honorable Apex Court laid down the conditions as part of para particular.
Yes.
Where an appeal or revision is provided against an order passed by the court or any other authority before superior forum, from the superior forums modifies, reverses, affirms the decision, putting the issue before it, the decision by the subordinate forum venges in the decision of the superior forum. The jurisdiction conferred by Article 136 of the Constitution is divisible into two stages. The first stage is up to the disposal of the prayer for the special leave to file an appeal. The second stage commences it from when the leave to appeal is granted and the special leave petition is converted into appeal. The doctrine of measure is not a doctrine of universal, unlimited application. It will depend on the nature of the jurisdiction exercised by the superior forum. The content or subject matter of the challenge late or capable of being late shall be determinative of the applicability of the measure. The superior jurisdiction should be capable of reversing, modifying, affirming the other putting issue before it. The Article 136 of the Constitution. The Supreme Court may reverse, modify, affirm the judgment if they are ordered. Appeal against which exercising its appellate jurisdiction and not while exercising the discretionary jurisdiction, disposing the petition for civil appeal. The doctrine of measure cannot therefore be applied to the former, not to the latter. An order refusing special leave to appeal may be non-speaking order, speaking one. In either case, it does not attack the doctrine of measure. An order refusing special leave to appeal does not stand substitute in case of an order under challenge. All that means is that the court would not incline to exercise discretion to ask to allow the appeal being filed. It is only a declination of the Supreme Court not to giving any leave to appeal.
Yes.
In the right of the law laid down, act on measure. Even the my learned friend, senior counsel, is discussing about the orders passed by the division bench of the Honorable Court in writ appeal. Among some of the owners.
Yes.
Because even though the Honorable Division Bench contended have recorded the contents of the petitioner, they did not lay down, discuss about the existing law on this regard. Because notification and declaration should not be issued on the same day. When there is Supreme Court categorically held, holds good, because it was not discussed at all, my lord. So even at best, it can be for inquiry. Moreover, my lord, the larger bench of this Honorable Court dealt with the comparison, my lord, page 115 to 136. Discuss about the declaration. Larger bench.
Yes.
1993 to ALT. Full bench, my lord. There are 3 judges of this Honorable Court. This Honorable Court clearly held what are the under which circumstances the inquiry has to be dispensed with. Even the inquiry has been dispensed with, my lord, they need to publish declaration only after the publication of the notification, which is a statutory requirement on section 4. What, my lord?
Southern paragraph, sir.
Para 9, my lord. The crucial provision, section 4(1) of Land Acquisition Act, as amended by Land Acquisition Andhra Pradesh Amendment Act 9 of 83, which reads as follows. Wherever it appears to the appropriate government,
What purpose you are reading that? What purpose you are reading 4(1)?
Because the declaration should be published only after publication of notice.
4-1 లో ఉందా అది? చదవండి.
Wherever 4.1 demonstrates the nature of notifications.
Is that relevant for us?
Because they need to publish the notification in the 3 modes.
చదవండి. Yes, please proceed.
Wherever it appears to the appropriate government, the land in any locality is deemed likely to be needed for any public purpose. Any convenient notification with effect shall be published in the official gazette into daily newspapers separated in the locality application. One shall be in regional language. And the collector shall, within 40 days from the date of publication of such notification, publication of notice of substance of such notification to be given at convenient places in the said locality. The last of the dates of which publication and giving of such public notices being enough reported as the date of the publication.
Yes.
For this purpose, I am reading.
Okay.
According to them, according to the counter filed by them, it is 810.
Yes.
810 is the publication of notification. That's the last mode which they displayed in the conspicuous places at MROs and all.
Yes.
So when these were the bracket words in subsection 1 of section 4 within 40 days from the date of publication of the notification were added by land acquisition amendment. The said distribution from the source.
Yes.
Para 12. Applying the provisions of section 4(1) as amended by AP Act 9 of 83, the public notice of the substance of the Gazette notification dated 5/1/1981 ought to have been given in the locality within 40 days after its publication in the Gazette. In the instant case, the local publication is admittedly not done. 10/4/81, 95 days of the Gazette.
Paragraph? Which paragraph? 12. Yes. Yes.
Say so in Milad at page 13, para 13, what is the effect of non-compliance? Then is the effect of non-compliance of requirements of section 4(1) regarding local publication of the substance of the notification. The question has been considered by 3 or 4 judges of Supreme Court, and the answer to this question has to be found on the principles laid down in these cases. The first station which needs to immediate reference was Chen versus State of Rajasthan. Despite the contention argued by the state that direction to cause the public notice of substance of notification to begin convenient places locality was only a directory provision. After examining the scheme so and so, 4, 5, 5A and 6 of the Act, Subbarao is speaking for himself and observed. This is the observation of the Supreme Court they have. What is the need and prominence of the publication in countless places? The Supreme Court heard its view by referring to the language of section 4(2) of the Act. It was observed. Indeed, the wording of section 4(2) of the Act leads to the same conclusion. Thereapon, it shall be lawful for any officer, generally as speaking, authorized by the government to go out of the servants and working for the The expression thereupon shall be lawful indicate that unless a publication notice is given, the officer or his servants cannot enter into the land, which is necessary condition for the exercise of power of entry. The non-compliance with the said condition makes the entry of the officer on these terms of so and so the officer.
Yes.
When discussing the various case laws, the honorable full bench of the Assembly Court set aside the notifications only on this premise violation of the statute. This is the purport of it.
Yes.
The other judgments I have cited regarding the action of nature. And the per inclusive concept because all the legal and the legal propositions, statutory requirements were not met by the official respondents in publication of the notification as well as publication of the declaration in this case, my lord. And the petition challenged the very publication and declaration, my lord, which are prior to passing of the award, when the petitions were able to demonstrate that these were against a statute or against a law laid down by the Supreme Court, my lord. There is no other option. The declaration is void under the law, non-extant under the law. And the consequent passing of the award in no way helps the official respondents.
Yes. Yes, GP Tuesday.
Yes.
Start from page 191. So TSHC is the counter affidavit filed by the member of the squad number 68. First from page 191.
Yes.
The lordship go to page para 11. Please do not.
Yes.
The title para 49 to 55. The subject of the land is now identified and notified for the execution of examining the matter carefully. This was filed in the year 2006. This request petition was filed on 30th day of August 2006. Meanwhile, my lord, in the year 2003, piece of land was assigned in favor of NGOs, which was already included in the whole petition. Now, this respondent in this particular affidavit saying like this, the lands in question are essential so as to ensure compactness of the cyber park being developed by the corporation. I submit that invoking urgency provision of Land Acquisition Act in the present case is essential and proper since the lands are urgently required for development of cyber park. In the year 2006, they filed this application by the said time. The lands were assigned to NGOs organizations for housing purpose.
Yes.
This was a developed layout. All the petitions, 106 petitions, all the 106 petitions purchasing the land admitting 2,000 square yards to some extent.
Yes.
They have got registered sale deeds prior to the publication of the notification. Still, the state is no way they have mentioned this land was assigned to respond number 29 even in this affidavit.
Yes.
Whether it is a corruptness or fraud on the
Yes.
I will leave it.
Item 33, yes, Srinivas Reddy.
Lords, this main these are lordships. This matter is coming up for the instructions of the sixth respondent, where an offer was made for providing a 25 feet road, and they are seeking for a 40 feet road.
Yes.
Your lordship wanted them to get instructions.
Yes.
25 feet is fine.
They are agreeable for 25 feet.
Very well, my lord. Let it be a consent order.
You filed any paper or any?
They filed a memo.
No, that is the conditions.
Yes.
Yes, you file an affidavit. Please, Was the matter on Tuesday?
We get fees for
Tuesday, posted on 16th for judgment. Yes.
Publish.
Item 34 to 39. Amendments, amendment.
Yes.
This is the Lordship's compilation. Yesterday.
Yes, yes.
I'll give a short reply on 2 points. First
Yes,
is
yes.
that the purpose mentioned in section 4.
True short. True short.
Very short. I have to distinguish about judgment.
Yes.
The purpose mentioned in section 4 is vague. Secondly, it's not a public purpose.
Yes.
Third is delegation of functions under 5A to LAO HMDA is bad in law because it is collector himself is a delegate.
Yes.
Put out a further delegate. These are the 3 points for which I to push.
That you already argued these points.
Last point I argued below is 6 judgments.
Vagueness, Mr. Adnan Rao argued it elaborately.
6 judgments which were London Advocate General cited. They're totally distribution on facts.
Yes.
And those facts I bring to your lordship's kind of. But Justice Nagarjuna Reddy in his judgment below covered both these aspects. The notification, there the notification was issued for township and future projects. His lordship said both purposes mentioned are vague. He also said they don't constitute public purpose. The relevant time I join us to kind of switch to that part of the judgment. But kindly see this, Lord. The reason for specification of the public purpose with specificity is to enable the objector to file meaningful objections. That objections can be raised only if he is made to know for what purpose the land is proposed to be acquired. There are 3 types of objections a landowner can raise. This is enumerated by the Honorable Supreme Court, 2007 HIGHCOURT 296.
This one.
There are 53 words. There are 53. It answers one of the conditions of the London Advocate General that we have not raised that any objection related to the public purpose. But now the objections under section 5A, 53, para 53. Para page 318 below.
Yes.
Now the objections under section 5A if filed can relate to the contention that the purpose for which the land is being acquired is not a public purpose. That even if the purpose is a public purpose, the land of the objector is not necessary in the sense that the public purpose could be served by other land already proposed or some other land to which the objector may refer. That in any event, even if this land is necessary for the public purpose, a special fact situation which the objector is placed, it's a fit case for omitting his land from acquisition. Objection 2 is personal to the land and objection 3 is personal to the objector. Now, in objection 2 and 3 types of objections, there is a personal element which has to be pleaded in section 5A inquiry. If the objections have not been filed, the notification must be conclusive proof of the said person had waived all objections which were personal and which he could have raised. However, so far as objection 1 is concerned, even in case objections are not filed, the affected party can challenge in court that the purpose was not a public purpose. This answers the context of the London Advocate General that we have not raised any objection related to the public purpose. But as far as 2 and 3 are concerned, my lord, in my case, they have been pleaded, but not considered by the district collector. I have said government land is available. That serves the purpose. That has not been considered by the district collector in this report. My objections are at page number 32. The 2 petitions filed 2 similar set of objections, 32 and 33. 2 and 3 are covered. As far as public purpose is concerned, London Advocate General relied on certain judgments. Kindly see that volume number 2 below, page number 39.
Volume 2, huh?
Volume 2, which I just now counted.
Yes.
The public purpose is mentioned in this judgment in para 3.
Page?
I just mentioned. Page 39 of that compilation.
Yes.
Kindly see page number 564, paragraph 3. To appreciate the controversy in the present appeals,
Yes.
to appreciate the controversy in the present appeal, it's appropriate to refer to the facts in the first matter. Civil appeal arising out of SLP number. It was the case of the appearance before the High Court that the government of Andhra Pradesh sought to acquire a large chunk of land in the name of public purpose for the purported development of financial district and elite projects. According to the action has been taken in colorful exercise of power in total violation of so and so. One of the contents which is referred to in the subsequent paragraph is vague. Then this is a batch of cases. In para 23, another purpose is mentioned. Para 23.
Yes.
As already noted earlier, proceedings have been initiated by the authorities in 2002. A notification under Section 4 of the Act was issued by the state government. The notification reads as under. Whereas it appears to the government of Andhra Pradesh that the land specified in the schedule below and situated Nanakramgoda village, Serlingampalli Mandal, Mandal district, needed for a public works to which for development of new projects by APIC, notice to that effect as hereby given all whom it may concern in accordance with this orders. The purpose mentioned as such is vague in this notification. But what the respondent did was they produced material to substantiate that this is not vague. That is available from para 83 onwards. Para 83. A special act was passed. Page 83. Paragraph 83.
Yes.
Learned counsel for the respondents invited our attention to the Industrial Policy 2000-2005 adopted by the state of Andhra Pradesh. Reference was also made to GOMS 427 dated 18/12/2000, under which the government decided to undertake mega infrastructure projects in the state to attract industries in the state and for overall development of the state. These documents gave enough information to the objectors to find meaningful objections. The policies laid down the guidelines for attracting and facilitating private investment in infrastructure. It provided for infrastructure project implementation in the private-public partnership requiring government support. The policy envisaged the need for a special legislation called the Infrastructure Development Act. An act was passed, supported by rules, guidelines, and sectoral policies. While idea was to constitute a special infrastructure promotion authority, having quasi-judicial functions, the task force was undertaken. Executive functions outlined in the IDA. The intention behind the integrated project was to establish Hyderabad as a major business from tourism infrastructure asset for the state. It was also stated in the background of World Tourism Organization report on the state of Andhra Pradesh in 2000 and in the light of Vision 2000 document prepared in mid-1990s, highlighting the need for tourism as an important economic driver of the state government initiated the project development exercise in 2000-2001 for an industrial standard convention center complex integrated with other components. In pursuance of the above policy, Andhra Pradesh Infrastructure Development Enabling Act has been enacted. This was the material that was available. So, having regard to all this, the Honorable Supreme Court said it's a public purpose. 128 onwards. So 128. Conclusions. Applying the aforesaid principles to the case on hand, in our considered opinion, it cannot be said that the proceedings initiated by the state for acquisition of land under Land Acquisition Act are illegal, unlawful, unwarranted, malafide, fraud, etc., etc. As already adverted earlier, the Andhra Pradesh in the background of World Tourism Organization report, Vision 2020 took a policy decision for development of the city of Hyderabad. For the said purpose, it decided to establish an integrated project which would make Hyderabad a major business cum leisure tourism infrastructure center for the state. The project is both structurally as well as financially integrated. It is to be implemented through Andhra Pradesh Infrastructure Investment Corporation
which has taken all steps to make Hyderabad a world-class business destination. APIAC is an instrumentality of the state, works as a nodal agency, developing the project which would facilitate social economic progress of the state by generating revenues, weeding out unemployment, and bringing in new avenues and opportunities for public at large. Development of infrastructure is a legal and legitimate purpose for exercising power of eminent domain. Simply because a company has been chosen for fulfillment of such a public purpose does not mean that the larger public interest has been sacrificed, ignored, or disregarded. It will also not make exercise of power valid by day, but collateral purpose initiating the proceedings. So this is the background in which this judgment was rendered. As far as our case is concerned, no material is produced. Even in the counter affidavit, nothing is specified. Yes. The second judgment is at page number 94, Milord. 1996. 1 SEC 250.
Yes.
94.
Yes.
So this judgment is referred to by Justice Nagarjun Reddy Milord in para 18.
Please.
Yes. Now kindly see para 3. Purpose is mentioned in para 3.
Yes.
The public purpose stated in the 3 notifications.
Yes.
The public purpose stated in the 3 notifications is for the implementation of housing schemes to meet the demands made by various sectors of population under Kalai Nagar, Karunanidhi Nagar, further extension of scheme. For the creation of a new neighborhood known as Kalai Nagar, Karunanidhi Nagar Part 2 schemes, and for increasing housing accommodation for the development of South Madras neighborhood, respectively. Inquiries under Section 5 were held, and on the basis of reports submitted in India, declarations under Section 6 were made sometime in the year 1978, and awards were passed in the year 1983. The writ petitions from which these appeals arose were filed in the year 1982 and in 1983, one of them even earlier. So, Your Lordship sees there were demands. Pursuant to the demands, this notification came to be issued, and there was adequate indication in the notification itself. That was Kalai Nagar, Karunanidhi Nagar. Further extension scheme. There was already a scheme. It was intended for further extension.
Yes.
That para 35 Milord, they said public purpose is a matter of fact which has to be ascertained in each case, depending on the facts of the case. Para 35.
Yes.
The next question is whether the public purpose stated in the 3 notifications concerned is vague. It must be remembered that what is vague is a question of fact to be decided in each case, having in the facts and circumstances of the case. By saying that the public purpose in the said notification is vague, what the respondents really mean is not that it's not a public purpose. This is the public purpose is expressed in vague terms and is not particularized with sufficient specificity. They are not in a position to make an effective representation against the proposed acquisition. Because their complaint is answered in para 38. About decision, and particularly the decision in Aptanur, that is 1975 4 SEC, do establish that whether the public purpose stated in the public particular notification is vague or not is a question of fact to be decided in the facts and circumstances of each case. And further, where a large extent of land is acquired, it would not be proper to insist upon the government to particularizing the use to which each and every bit of the land so notified would be put to. This is the ultimate principle that is laid down. The 3 notifications concerned herein we are told pertain about 400 acres in all. The Lordship says when the public purpose is mentioned with certainty, it's not necessary to further mention as to how each particular bit of the property will be used. The third case is below 1967, 7 SEC 450, which is at page number 117 of the compilation. This is a second case following 1996 1 SEC 250. I don't propose to read it because it followed 1996 1 SEC 250.
Please.
Then the Other case is 1999 2 SCC 384. Page 121.
Yes.
22, Lord. As pointed out in the above judgment, there is no need that the land proposed to be acquired by the government for a purpose. Public purpose should be for the same purpose or use mentioned in the master plan and zonal development plan for that area. Nor will the acquisition be invalid merely because the land proposed to be acquired is for a purpose other than one permitted by the master plan or zonal development applicable to that locality. Acquisition will be valid if it is for a public purpose, even if it is not for the type of user permitted by the master plan or zonal development plan in force at the time of the acquisition made. It will be for the beneficiary of the acquisition to move the competent authority under the Development Act and obtain the sanction of the said authority for suitable modification of the master plan, so as to permit the use of the land for the public purpose for which the land is acquired. In fact, it may be difficult for the beneficiary of the acquisition to move the competent authority under the Development Act seeking permission to change the land use, even before the land is acquired or possession is given to the beneficiary. On the principle stated in the absolute case, it is clear that the acquisition for a public purpose and obtaining permission from the competent authority under the Development Act concerned for change of land use are different from the one another, and the former is not dependent on the other. These are a different question altogether. There, my submission is public purpose was mentioned with certainty. The complaint was regarding use of the land to the master plan. They said the competent authority can always be approached. In our case, our complaint is there is no certainty in the public purpose mentioned. Then there is absolute case 1975 4 SCC 285, page 131 of this compilation.
Yes.
There are two bullets.
Yes.
A notification under section 4 of the Land Acquisition Act, herein after report to the Act, was issued on November 3, 1959, stating that an area of 34,070 acres of land was needed for a public purpose, that is planned development of Delhi. Between the reason is also mentioned in this paragraph itself. Between 1959 and 1961, about 6,000 objections were filed under the section 5A of the Act. The objections were overruled. This is all on the proposition. Paragraph 4, next. Why it was upheld will be evident from paragraph 4. The influx of displaced persons in 1947 from West Pakistan into Delhi aggravated the problem of housing accommodation in Delhi. With the extension of industrial and commercial activities and the setting up of foreign embassies, Delhi acquired enormous potential as an employment center. The consequent increase in the population was not accompanied by an adequate expansion of the housing facilities. There was haphazard and unplanned growth of houses in different areas. Land also was not available at reasonable price, as substantial portion of the available land suitable for development has passed into hands of the private enterprises. The government found it necessary to take effective steps to check the haphazard growth of houses and to prevent substandard construction. Therefore, the government framed a scheme for planned development of Delhi. This is totally a different background. Just then, India had retained independence. Capital had to be developed. These are all in different consequences. The lawsuits also found that there was around a delay in challenging them. That may not be relevant for us. But kindly see the last judgment, page 146.
Yes.
1972 SCC 264. But here the acquisition was for a cooperative society.
Yes.
Well, this case turned on the amendment made to Land Acquisition Act by Gujarat.
Yes.
This case was decided on the basis of that amendment, not under the Land Acquisition Act, 1894, Central Act. Kindly see paragraph 4.
Yes.
Gujarat legislature by Gujarat Unification Amendment Act 20 of 1965 amended clause F of section 3 of the Land Acquisition Act 1894, which defined the expression public purpose. As per that amendment, after subclause 2, the following clause was added. A housing scheme which the state government is from time to time to undertake for the purpose of increasing accommodation for housing purposes shall include any such scheme undertaken
Yes,
and
yes.
with the previous sanction of the state government by a local authority or a company. So that amendment will not permitted acquisition of land for housing schemes with the
Yes.
sanction of the state government. That's why that acquisition was upheld. That has no bearing on the present case. Amala, kindly see the judgment of Justice Nagarajan, as the Dr. Then was.
Yes, that already read there.
I'll just mention because the purpose may not. I'm sorry.
Yes.
So my summary says this is not a public purpose. It is absolutely vague. They are deprived of an opportunity to file any objections. At any rate, my delegation is bad. 4 also has to go because that can't be separated, segregated.
Yes.
Just to back this matter on Tuesday, Minister, only few submissions and two.
Even reply is only distinguished the decisions relied upon. Nothing on no other submission.
Yesterday.
Seek instruction and 230. Discuss if required, I'll accommodate, but really required, I'll grant you time. Yes. Yes. No, discuss if really seriously is required, I'll grant you time.
Only wanted two aspects, that is the reason why the general asked me to. As a first item, only it will take 5 to 10 minutes. That's all.
Item 39 filed by some state platform of 39.
Yes.
The last one, they also probably stated that the withdrawal from the government has issued a COL last year. And in that, the government directed the district collectors to submit a proposal for earlier withdrawal. But page 26.
Yes, that is already argued.
So one more thing you also got the time of they have issued a final notice for petitioners and the petition all the some of the platforms submitted their objections and some of the class was regularized already. And what is the then gone the legal general says that the title they have not filed, they have not stated any single whisper with the counter with regard to the title. And your lordship already noted that collector has accepted the rejecting the 5 objections, color accepted. We are the owners of the plots and
yes.
So there is no dispute with regard to the title of the property.
Tuesday?
10 to 15 minutes.
Yes.
Item 40, A. Ravindra Reddy.
Yes.
Not quite.
And another point is who are in possession, right? The land has been entrusted to the housing cooperative society. Now the houses are in existence.
What is this
Peaceful.
number?
What about what are your instructions?
Not in our, it is vacant. Yesterday also opened the party has formed us.
Trusted in the year 2006.
The petitioner's land is concerned, you said they got an interim order. Paragraph 4. You didn't say anything about that.
It has been entrusted in the year 2006. Para 3, your lordship, we have stated that we have entrusted. It's filed in the year 2009.
You have instructions.
Yes, ma'am. It is vacant. Signed vacant.
What is the activity going on? Any activity in that?
No. Next to this property, activity is going on by private sector. This flat is lying vacant.
Petitioner and his mother has sold it in Prabhavati University.
He has Patadar passbook in his name. And admittedly, the assignee was no more. And his impugn order also takes note of the legal heirs, including the petitioner. He was not put on notice.
This has been issued to the Chinese and purchasers. We have stated so. Page 18. And the group AP assigned at 1977 have been issued to the legal heirs of the assignee and purchasers of the land. Legal heirs means the petitioner also confirmed.
See, go to page 19, last but one paragraph.
Last but one paragraph.
Yes. Suresh, yes, no. See that due to which he could not serve the orders and requested to pass revised orders. What is that orders he could not serve? Perhaps that is only notice. There are no orders by then.
This is the proceedings of the
Yes, Tasildar. Yes. That is confirmed. In spite of raising specific contention that no notice, that was not answered, but a cryptic order is passed by both RDO as well as Joint Collector.
but the major assignee is very important.
The Pahanis and all support their case that both the brothers got equal extent of land. This land.
property does not exist.
His petitioner claims to be in possession. And already there is an interim order operating from 2009 onwards. And you never said position, you took position in 2006. Any of them are 2009 writ petition now. Let's see here. Mangali Bhatt.
That hard copy might have been reserved. They are not available.
Then what is this order? If that is our order already passed on 5/8, what is this order? This is the order passed under 4. This is only order passed under 4. Order to resume the land.
5/8.
No, if 5/8 an order already passed, then why 6/8 order then?
Maybe
This is only order under resuming the land.
This is 6A.
6.8 is the resumption order.
Yes.
If 6.8 is the resumption order, how can you say 5.8 also a resumption order?
5.8 is the motion proceedings. This is the resume back to the position. This proceedings.
This is the order passed on the ground that considering their explanation of the purchasers.
This procedure in the reference has been mentioned.
You have the record?
Got it.
Then produce the record. Use it. Produce the entire record pertaining to office of the Tahsil of Pune. Tuesday and the same charge. Yes.
Item 41.
It can be called.
It is represented by one council petitioner that the respondents are complied with the order passed by this court WP number 18244/2020. Dated 8/3/2022.
Item 42.
The grant two votes each time, loss of complaints. Request been transferred to a person.
Request of land GP for the request of the 3 weeks. Complaints.
Item 43. In Abhishek.
For reporting. Item number? Earlier than appearance. Antena? No, if appearance is there and so that you can dispense with it because they are complying. There.
It's not formally discussed, but on last occasion, the last appeared. The last occasion. That way.
Oh, that matter.
Yes.
You are appearing for repetition.
Yes.
Their cooperation is required for complying with it. That's. Oh, just wait. I have not come to your matter. No, this previous matter, Form 1 was issued. Antemnar was present? He was present? Yes. Please switch it. Repeat that.
Revenue post after 3 weeks for reporting.
Request one. GP presented that the process of complying with the order passed by this court is already started and is likely to face 3 more weeks time and we will do same post transmission for reporting compliance, appearance of the respondent container. Yes.
Item 43.
Yes.
From the last occasion, they start saying it will try to reply to the contract.
Yes. Who is for petitioner? Yes.
These are not compliant.
What is your stand?
Saying that you already sold the land and they are not made parties.
In fact, the petitioners have to make party
People as participated.
My lord, in fact, it was, if you remember, if you see the record, the order for the interim order that was passed by Solomon report was recalled. Thereafter, no order is passed.
Order was recalled.
Recalled. Technically, there is no order in the writ petition. It was recalled on the ground that the petition content case, though she filed a caveat, the papers were not served to her. So on that occasion, court also citing the Supreme Court judgment, my lord, the order has been recalled by my lords. Thereafter, there is no order in the writ petition. That is one thing.
During the existence of the interim order itself, they have converted agriculture and land into non-agriculture. Now the petition, point three has taken stand. So
When it was recalled,
And pass on the order, the order.
recalled.
Okay. In paragraph 3 of the counter. The status that
When the registrations took place?
no,
3/7/2022.
I just submit for them.
Yes.
Paragraph 3 of the counter, they have stated that regarding the conversion of the agricultural to non-agricultural, which has taken place in the instance of one Musa Shankaraya and Komitapalli Ramesh Jadala Satish in respect of the extent mentioned, it is not fair for the myself or the deceased Rajana have applied for the said conversion of the land at our instance. The conversion has taken place. In fact, Revati Rajana, who has passed away and his son is there right now, has sold an extent of 0.1050 guntas of land under sale deed number 7 in favor of Nuka Shankar, who has made an application.
When that was sold?
That was sold in 2021, March
The
2021.
matter pending before the special tribunal.
March 2021. He also sold an extent of 0.070 guntas under sale deed number so and so in March 2021 in favor of Komitpalli Ramesh. He also sold an extent of 0.1050 guntas under sale deed number so and so in March 2021 in favor of Jadala Satish. Thus, the said sale transactions have taken place much prior to the order of the special tribunal and the filing of the present petition. Those vendors seem to have applied for conversion of the land and the same was recorded by the Tahsildar Tenure. Thus, there is no violation of the order of the Honorable Court dated 14/6/2000.
Now, according to you, what is that they did? What they did?
During the pendency of this interim order, they have converted agriculture into non-agriculture on 3/7/2022 and 4/7/2022.
It's only conversion, not
Conversion.
not alienation.
Not alienation, conversion. But the order is status quo should be maintained. Your Honor.
And one of the
The specific direction to the respondent number 4.
You got to increase in the revenue records.
Yes,
and one of the alleged containers has expired. Mr. Revati Rajan had expired.
specific direction was
Only increase in the revenue record.
the whole purpose of repetition itself fails if that is the case.
They have to make up a repetition, but not in-
The maintain status quo till the next.
they can't see that. Technically, by virtue of what I've showed us,
In the specific direction was
direction
No
was
interim order passed again in the petition.
No, yes. The matter was deferred, but it was not.
Then any entries are altered now in the revenue records.
Yes, you know. No, because of these entries, now they are seeking time. On the last occasion,
No, what entries are altered now?
the petitioners have sold the property
That is in 21.
2021. During the substance of this petition, now they have converted.
Conversion is all. Conversion will not result in changing the entries in the revenue record.
and the said conversion is also in the instance of the persons are purchased, not the alleged container.
What the petition itself says if that status quo is not maintained.
You understood? Understood? You have
Yes,
any?
yes, I understand. But the whole petition itself says if that is if they are not maintaining status quo, I won't be.
No, no interim order in your favor now. No interim order is, whatever order passed is also recalled by me.
But the tribunal has given an order in my favor.
This contempt case is filed. Alleging violation of the interim order dated 14/6/2022 passed by this court in WK number 24901 of 2022. Whereby this court directed the respondent number 4 therein, that is Tahsildar, yes. Second week, your date will be given. Second week of February.
Item 45, Saurabh Agarwal.
What is it? Only after implementing CCLA. Yes. It is presented by the unconsent court application as well as candidacy for reviewing that. The order passed by this court number 7310 of 2018 dated 20 July 2020 is complied with by the respondents. This way, yes.
Item 45, item 46, G. Ramchandra.
Pardon?
Hearing date will be for the collector, but 16th of December.
15th December.
16th.
Is essentially an AGP for revenue that the respondent collector has fixed the date of hearing for disposal of the matter as 16/12/2026. Next time for reporting coming. 22. 29/12.
Item 47, G. Veerapapa.
Same. 18.
18
11, 12. 8/12.
Item 48 and 49.
My lords, I beg to appear online, my lord, in item 48 and 49, my lords.
In which
What is the contempt name?
11/7/2023.
Any appearance ordered in that?
And 7, it is my lord.
Mr. N. Sridhar. PC 1172/23. Yes, after having heard land counsel for the petitioner as well as landing counsel for respondent, this court is of the considered view that it is necessary to complete the you are appearing for? Petitioner is. Is 7 GPR complied?
Including a notice issued. But the others have not been issued in the last week was regarding earlier the 2 acres and rectified as a 4 acres.
The understand అయిపోయింది కదా.
Yes, you last one.
His counsel for the petitioner as well as and AGP for revenue represented that the order passed to this court in W 447/2022 dated 5/2023 is complied with by the respondent. Yes.
Item 51.
Petitioner are all major daughters, were seeking for arguable benefits as per GOMS number 88, which has been amended, on par with the major sons of Kalapalli village, Mancherial district, Adilabad district, Mancherial district. The operative portion of the order on page 43. On the last occasion, it was argued at length, judge and the council, as the respondent said that they will comply the order so far as 35 petitioners are concerned, considered as of today. That is coming under caption for compliance. So far, they have not complied, my lord, for no, at least 35%. 35.
Issue? What is the order passed by this court?
The operative portion is on page 46, my lord.
Yes.
Primary. For the associated reason, the official respondents are directed to conduct a survey and identify the daughters whose parents' land structures were affected in the project. It is needless to observe that the parameters for extending the benefit for a daughter should be that she should be a major as on the date of notification under section 4.1, that she should be dependent on the head of the family and should be residing in that family as on the date of the notification. After identification of the daughters who meet the above criteria, the authorities concerned are directed to see that the benefits of the package which have been extended to the sons in the project affected families in project.
R&R package.
Yes, R&R.
The note 4.1 notification is the criteria.
Yes.
Subsequently, a clarification was issued.
By
Yes, rate of displacement. Yes.
This person are to be extended to the major daughters on top of the major son.
Who has to do all this?
The respondent number.
How Singareni colonies will do all this exercise? It is for the LAO to do.
Only demand notice will be issued. Since the demand was issued, therefore, we said that give us the details of the how we should categorize. And they did not. We are accepting only for 35 people. We have filed counter. So on the last edition report, they directed us some at least compare with the tax rate. They report to the RDO issue demand notice.
Why LAO is not implicated? Whatever LAO identifies and the company will pay. Not treated them as parties to the contempt. No, LAO has to identify the persons who are eligible for such benefits. And it's only the company will only pay master. No, it said official respondents. Include proper. Yes. Council for the petitioner seeks to be necessary parties to. Post on when? Yes.
Item 52, J. Manoro.
Sorry.
Question you are
Yes.
So when the petitioner before the last can be passed.
Yes. Monday, Tuesday. Get the stuff for it.
Item 53, B. Shivakumar.
The respondents will kindly pass it. As per the directions of this code, we have sent the these to R6 to R9.
It's for petitioner. Post on first. Yes.
Item 54, CS Srinivas.
Okay.
Item 55, Simramon Reddy.
Tuesday. Tuesday. Tuesday, and then item 54. Yes.
Senior counsel registration to be updated in this matter. The question to be 2 weeks of time.
What is this contempt?
Voting is concerned. Tell us what is scheduled. Repeated by the executive artist coming for taking a view that the better than the 95 proceedings of the appropriate.
The stuff all on this whether it is not posted. Yes.
Item 56 and 57, G. Vasant Raidu.
Yeah.
Next week. But counter.
Then I will be over part 2.
Counter. Already granted almost 1 month time. 1310 you are granted time.
Convenience of the commission.
Pardon?
The convenience of the commission. Next week we get the sign for it.
Stop. Finally postponed. 24th finally. 24th finally.
Item 58, Sai Krishna Mondro.
In this R1, Jagan Madhav Rao is wrongly treated for taking the R1. In item number 56,
Your name is there?
name is there. R1 is wrongly.
No.
There.
Item 58,
Yes. Notice surveillance on article. Notice served?
Notice.
At 5 notice issue. లేదా comply with the order dated 20/10/2022. Notice is not issued. Fresh notice ordered.
item 59, S. Lakshmikant.
We are permitted to withdraw this contempt case, my lord, since my lord, repetition itself was, my lord, dismissed as withdrawn.
Yes. Is represented by and counsel for the petitioner, the main repetition. 3468 for 2018 itself was withdrawn, was dismissed as withdrawn. Nothing occurs in the content case. Content cases.
I'm a blush.
Item 16. Hare Krishna Modu.
Include showing the notice only, same. Responding. Outside. Into this. Same as the triangle, 23 colors. Same. Notice.
Item 51. Ramchandra.
Yes.
Is not directed.
Yes, who is appearing for respondent?
Respondent 192 contesting this. In the counter also.
Yes.
I filed a partition suit to block. Here is the P1 and P11 class. Other parties, like P1 and P11 are the contesting. The people in the partition suit block, which was filed by the block.
You filed the suit?
Yes, I filed the suit partition. Claiming is against every land with property.
You, last title shows you are a defendant number 12.
Not casting. Yes, defendant number. Yeah, that's what I am submitting. If you will not file blood partition, fine. If you will not file partition. Sorry. And G12 was thought to be implemented at the instance of D1 and D11.
Who is sort of implemented?
D12 was implemented partition in the partition.
Yes.
D12 is the wife of the plaintiff. And on the ground, the properties were acquired on behalf of the D12 Millard, on behalf of in the name of wife Millard, though it is joint family property. But in the partition suit filed by me Millard, and there I have not mentioned that properties on the name of my wife are pertaining to joint family property. There is no evidence. She acquired on her own Millard by virtue of her own personal.
Who filed implead application?
D1 and D11.
They say properties are standing in her name also.
And because she being the wife of the plaintiff, Millard, the property.
Did they plead? Have they pleaded so in the written statement?
They have not pleaded. They filed the written statement, and subsequently another IA has been filed. On the other hand, Millard, D1 and D11, argued that they got the oral partition in the year 1995 itself, the para 2 of the WS.
No, that's totally different as well.
And Millard only because I filed the partition suit against Schedule A and B.
Of lunch.
With your permission, Lordship.
Yes, yes.
Item number 25, your Lordship, that is so that will be taken on.
Item? Transmitting.
For pronouncement of orders, item 21, G. Madhusudan Reddy.
Accordingly, the ensuing memo dated so and so is set, the matter is remanded back to the respondent number 3 to consider the claim of the petitioner by duly taking into consideration the overall facts and circumstances of the case, including the observations made in this order. The petitioners are granted liberty to submit a application for respondent number 3 within a period of 3 weeks from the date of receipt of the copy of this order. 3 weeks. Pardon? No, I said 3 months time for disposal. 3 months. For submitting representation, 3 weeks.
Item 22, CS Siddharth Sharma.
Petition is disposed of directing respondent number 4 to 4 to take steps for considering the case of the petitioners for allotment of land situated in survey number 152 by 1 of so and so, or for allotment of alternative land in terms of the orders passed by this court within a period of 3 months.
Item 23, T. Venkatraju Gaur.
Accordingly, the petition is disposed of, giving liberty to the petitioner to submit individual claim petitions before respondent number 3 by narrating the basis for their claim within a period of 4 weeks from the date of receipt of a copy of this order and submission of such individual claims of the petitioners. Respondent number 3 is directed to refer the claims of the petitioners under 76 and 77 of the Act for adjudicating as to whether they are entitled for such compensation within a further period of 6 weeks.
Item 24, T. Venkatraju.
This Monday will get. These 3 are not connected at all. You said all 3 are connected and you have argued. This I will pass orders on Monday. Item 24. 24 orders are. Acts are totally different. Claim is different. 24 I will pass almost in the same lines. 24 Monday. Tuesday.
Item 25.
According to the petition is allowed directing the respondents to pay compensation by duly passing an award in the name of the petitioners in respect to the subject land, together with all benefits as may be entitled under the provisions of Act 2013, irrespective of payment of compensation to the so-called enjoyers, as expressly as possible at any rate within a period of 3 months from the date of receipt of the copy.
Item 26.
This is totally unconnected. Nothing. I have gone through the entire record and absolutely it is unconnected to those two matters. Just simply saying connected don't lead anywhere. It's the matter in the regular rules. And counter is not filed in this, and you didn't argue the matter anything, and you simply said connected to those two matters. Come on next Thursday in the list.
Item 27 and 28. Please, Ravi Kumar.
The letter of the vote, both the repetitions are allowed, declaring that petitioners are entitled to be treated as a separate family within the meaning of second proviso to clause M of section 3 of Act 2013, read with explanation to clause M of section 3 of the Act 2013, and also for extending R&R benefits under the provisions of Act 2013. Respondents are further directed to extend the R&R benefits by virtue of their displacement pursuant to the acquisition proceedings undertaken by the respondents under the provisions of Act 2013 in terms of GOMS number 120 or any other scheme that may be applicable to the petitioners or expressors to subject to verifying their eligibility.
120. 20 is a rule which has been made pursuant to Act 21 of 17.
That is a state scheme.
There are separate rules for the purpose of Act 30 of 2008. That you are not specific.
Yes.
Because it would be running contrary to
I understand. Yes, I'll come.
Not to say rules made there.
Yes, I'll make it.
Item 29. Ready, Chinola.
Better therefore, and also considering the order passed by this court is also. So is entitled to renewal of passport for a period of 10 years instead of 1 year, and according to petition is allowed, directing second respondent to renew the passport bearing number so and so for a period of 10 years and reissue the same subject to payment of usual charges by the petitioner as expressed possible within a period of 4 weeks.
Right. Item 61, continue.
Yes.
61, huh?
61.
Yes.
The statement of the parcels filed by the contract. Consumer even and dealer on the other parties. Should order you are the for 26 year after discussion on 26, 20 water numbers.
Let us see the application once.
37 is
Yes.
Number one, getting by there is a number of we file up seeking relief of partition separate properties. We filed our written statement in government stating that this will be great part. Respondent and mentioned is first to be disturbed in the name of section 3 property. Name in court so that it is only a process and has no independent purchase the animal property fully discharged in the security of the state. Therefore, this necessary to declare its in the purpose of as party dependent on whose name and properties are given in the petition. Again, number so found under article 20 That's how the petition had been filed.
What is your counter?
And counter may not party.
Yes.
This is the counter of later counter Miller. And it's 43 is Millard Michael. That is my candidate 43. That I have stated Millard. The properties were purchased on my own funds to acquire through from my parents. And apart from the other business activities carried by me. And I have no connection with regard to the joint family. Status of joint family property between the plaintiff and defendant number 1 and 11. And I do not form the legal heir or legal representative of the family. There is no existence of joint family, and I have no direct interest in the joint family properties of plaintiff and defendant number 1. I am only wife of plaintiff. That doesn't mean that the property won't be subsequently.
Properties are purchased after your marriage or prior to your marriage?
After marriage and after oral partition 97 Millard in that. In the written
No, if that
statement-
is the case, that is totally different aspect. After the oral partition and all that, there is a different aspect. But if there is an allegation that your husband has purchased properties in your name from out of the joint family funds, then
only Millard joint family funds they have not stated. They to purchase properties. If there is no joint family nexus or nucleus, they have been living since so many years, Millard independently at their respective places. That's what I have treated as a plain. Only partition was filed Millard against the suit scheduled property and B only. This dependent has been included other scheduled properties. Millard.
they are entitled to.
But with regard to the properties, Millard, how acquired Millard was stated in this counter affidavit.
That will be decided after the evidence.
Assistant is mere owning of property on my name. And without there being, I am not the member of the joint family. I am only by.
You need not be a member of joint family.
Yes. But I should have some interest.
Properties can be purchased. No. So properties can be purchased in the name of family members also.
Also, but that doesn't mean that I do not have any other source of income.
No, that will be decided by the court at the time of trial.
The main dispute is clear to schedule A and B properties. I have the partition suit.
Yes.
Yes, against my brother and E11 is his son. And other members are not prosecuted.
If there are other properties which are joined to both all the parties,
How I got subsequent. These are the ancestral properties. I have purchased it through registered states from different persons. And from source of acquisition of funds also I have mentioned in the statement because I am the only one daughter to my parents. My father was a retired HC.
let us see what is the pleading in the written statement.
Yes, yes, wait till this. Counter the rest for kindly in the IE.
Your counter will reflect your husband's counter only. Then, yes.
Written statement you asked by kindly in the 46 to 51.
No, these are written submissions. Where is the written statement of D1 and D11?
Rate Millard is rate comes Millard from 50 to 1.
Where is that pleading about property standing in the name of petitioner here?
And we also spent kindly in the written statement Millard. Specifically, there has to be A Millard. There has to be A. 66 page.
Yes.
And specifically they admit about the oral partition of brothers.
That is totally different aspect. If there is already partition and suit will be dismissed.
Subsequently, subsequent oral the properties could be acquired also. That doesn't mean that if some other leftover properties in partition is weak, but these properties could be included.
Yes, please read. Yes.
These defendants submit this after death of their father, court of Govindarity, grandfather of the plaintiff, when the court of Saraswati made a oral family settlement in the year 1995 with the consent of the plaintiff, defendant number 1 and court of Ramdevi, and Srimati K. Sumiti Garu, as per outside oral family settlement, the plaintiff John K. Nance
Students, survey number 588 of 586, 12.50. Convection survey number 2.67. Total area comes to 50.38 acres. 28 of meters, Nala Mukherjee West, Imam Sultanahmet, and every other should one be particular classes strategy 84. 91 exists till today. 18 different number of brother late here on the jointly sold the lands. This is particulars of all, also they also sold the lands also. Detailed versions are given.
So you admit this partition?
Dependence may not time.
No, are you admitting?
95 partition. Oral partition, dependence claims are also admitted. Without regard to schedule, there are risks. Because there exists with regard to disputes, with regard to schedule A properties, A and B, I specifically find the case against my brother and his son. And his son. All the particular passports, this the issues of passports and identities to different extents, it indicates that there is severance of joint family status among the brothers.
Where they said about petitioner hearing? The written statement?
Page 72, last law line. Page 72. Last page 70. The agent purchase the property is mentioned in Schedule C annexed to this written statement. Purchase the property mentioned in Schedule D annexed to this written statement. The name of his wife. Who is right without any independent source of income, which are liable to be partitioned by scholarship one of share. And both of solution is necessary and property, lesser property, proper party to be case number 116, and she may be included in a and the potential one and filing an application under the Agents of order 1 in 10 of CPC to complete this election status as a party and the POS. Along with the written statement, we filed the schedule property D, that is page number 75. Schedule D is purchased by the plaintiff. That's it, by Schedule CD is annexed along with the written statement. That is page number 75. 75 contains the schedules C, D, E. D is concerned with the present position. There are 6 items in D schedule property. Page 75.
Let us see the plaint.
We filed a document, separate document also. Date is 52 almost 6 class. It contains only A and B schedule. That's all. We filed a written statement stating that some more properties are.
You say that they are the undivided joint family properties are there.
Specifically, paragraph 5,000. Pedigree is also given.
No, paragraph 8 said, you say that those suit A schedule are undivided joint family property.
Now we are D schedule. They are served.
Now they say from the income derived from A schedule, you purchased these properties.
I'm not saying that. They say that only the properties are on the name of wife. And that is the reason that she is not an employee. That is the reason.
No, that is the case in the written statement.
Yes, that is there only. When the property is separate on the name of wife, Mila. She is not an employee. She has no source of income. That is the reason the properties could be included.
Purchased by the plaintiff. That's what they say.
It is only allegation.
Allegation only. Pleading only allegation and it is subject to proof only relief will be granted.
In partition matters to us, knows Miller. As far as this life is concerned, Miller, she is a third party. Partition should be filed among brothers. And she has no proportionate interest in the property.
Not necessary. She may not be entitled for share. To be entitled for share, she should be a co-person.
She has interest in property. Without there being any interest in the family property Miller of her husband Miller, merely because she owns property, that doesn't mean that she could be included.
Properties are already included in C schedule.
Descheduled property now start to be included. Because she is owning property land, she start to be included as before.
Here it is mentioned as C schedule, para 7, page 76.
He Miller, along with the return statement, he filed a separate schedule Miller CDE. This Miller purchased the property by the plaintiff in the name of his wife. There are 6 items in the schedule. Page 75 Miller. Page 75 of the return statement. There are 6 items. Then Miller, along with the return statement, a list of documents also filed. Page 78. Page 75 schedule.
Yes.
75 serial number 20 to 24 your last mechanism. List of document. Page 78. Certificate copy of the sale date so and so dated. That is item number 1 of the schedule. Serial number 20 list of documents.
Yes.
It is purchased by plaintiff in her name, wife name. Then serial number 21. Item
Yes.
2 of schedule D.
Yes.
And all our plan is also filed.
Yes.
The assessment kindly consider one aspect. Only because wife is owning property and split between the brothers. And without owning of properties by the wife.
Dispute between the brothers at the instance of wife.
Not at the instance of wife. At the instance of D1. At the instance of because I find parties issued against D1 and he is done because interfering in the settlement to settle amicably about the disputed portions of A and B. Now
No,
the story was
you claim that properties are there are undivided family properties.
because the properties are there, C schedule and D schedule properties. I am not concerned about those things. I being the owner and possessor and the acquired sister said it's Miller. And I being a third party to the partition proceedings.
Yes,
Under the law also, I should have some interest in the joint family properties.
Now you have interest in deep schedule.
The treated as interested person. My point, as far as Miller, last month, kindly consider in joint property matters Miller. I could not have directly co-personal interest to be developed to me.
Not necessarily you should have a co-personal interest.
Because it is partition Miller.
Show me any law that a third party cannot be impeded. Yes.
It has to be exercised. If the proposed party has some interest in the property,
Not necessary.
that is not under the.
Yes, yes, show me that.
Yes. Last is by Candice CAR 1992 Miller. AR Supreme Court 1946 Miller.
Yes.
Para 18. Para 13 and 14.
Yes.
13 and 14. 13 was lacking.
Yes.
A clear distinction has been drawn between the suits relating to property, those in which subject matter of litigation is a declaration as regards status of legal character. The former character, the rule of present interest as distinguished from the commercial interest is required to be shown before a person may be added as party. It cannot be said that main object of the rule is to prevent multiplicity of actions, though it may be incidentally highlighted. But that appears to be a desirable consequence of the rule rather than its main object. The person to be joined must be one whose presence is necessary as a party. What makes a person as a necessary party is not merely that he has relevant evidence to give on some of the questions involved that would make him a necessary witness. It is not merely that he has an interest in the correct solution of some questions involved and has thought of relevant arguments to advance. The only reason which makes it necessary to make a person a party to an action is so that he could be bound by the result of the action. The question to be settled, therefore, must be a question in the action which cannot be effectively and completely settled unless he is a party. The line has been drawn and a wider construction of rule between direct interest and legal interest, commercial interest. It is therefore necessary that the person must be directly or legally interested in the action in the answer. That is, you can say the litigation will lead to a result which will affect him legally, that is by curtailing his legal rights. It is difficult to say. The rule contemplates jailing as a defendant, a person whose only object is to prosecute his own cause of action. And that's how we learn. You should have direct interest.
No, if tomorrow court says that this is also a property purchased from the joint family funds by your husband, will you not be affected?
Then it is found at the plaintiff's risk. The plaintiff was not added. It is the plaintiff is dominant like a losses may carry under the
No, no, defendants are seeking relief in respect of those properties.
That's true, man. That's true. But
That doesn't apply in case of partition suits. The principle that you are relying upon has no application to the partition suits.
It is between the brothers. Right? Some of the brothers are left in the law, some of the legal heirs are left.
Yes,
in
and
the law. Judgment is there.
enough, it doesn't require. Yes.
230 matter, admission 87. 230 Ajay Kumar. 27.
Serial loan.
Item 62. Give encourage for
Yes.
Status quo order is pending that the second respondent alienated the property. Ever of the status of this legal road direction.
Yes.
Right to question. Of the above status quo activity shall be maintained by both parties in all respects. The cancellation of the Pandara area acquired is not direct to maintain status. The scheduled property mentioned in the affidavit at page number 70. Close one. This mentioned in para 5. The very same property not alienated by the second respondent hearing to the third party. At page number 19. The boundary is also except not mentioned same.
Page number?
Page number 17, writ affidavit boundary is not. Page number 19, the alienated property by the second respondent. Bottom of the page. East property of Kondaboina Rangaya. Page 19 also East Kondaboina Rangaya. Again, south property of Chittimadi Venkata Narayana. 19 also same. And west also mentioned same. Kondaboina Vasantarao west. In page 19 also Kondaboina. Except not they are showing not as Dari.
Where are the boundaries in this? Page 19 boundaries are shown where?
Bottom of the page, not box.
Schedule.
The first respondent file counter, second respondent having this. Respondent number 3. Respondent number 2 is ordered.
Who executed this document?
R2. R2 is party to the restriction and not as respondent for file.
Who is appearing for R2?
This is the order to R2.
Why notice is not? What are Respondent number one says,
He says that among other grounds, he saying at that time he is not pursuing at the point of time.
then impute that person. Who is R4? Station.
Police. Or three is not who obtained property.
How police are concerned with this?
The petitioner approached the forcefully they tried to vacate the premises. He approached the police authority. They themselves threatened the petitioner. She also approached the superintendent of police. They filed complaints also.
Notice to respondent number 2.
'64 and '65 go together, your lordships. Your lordships were pleased to dispose of a similar contempt in another village in this matter, your lordships, where the NHAI had
To the district court and it is to the condition of the same. But
where the NHAI had agreed.
we are in the process of depositing with the RDO lordships. The lordship just to be pray for some time lordships so that the process can be completed.
How much time?
It's 8 weeks will be getting the process.
8 weeks they're asking time.
I'm sorry, your lordships, I could not hear the council.
8 weeks for compliance.
Yes, your lordships may say 6 weeks, your lordships, because a similar matter just last week in Kandarpalli, your lordships had passed final orders where your lordships had stated that they should.
Please wait. I'll take all necessary steps for complying with the order passed by this court and finally 8 weeks time. Yes.
Your lordships had granted 6 weeks.
8 weeks, yes.
Yes, your lordships. Obliged.
20th.
Yes, 22nd December for complaints. Reporting complaints, yes.
Item 67B, Rohit.
Is the order? Status quo order has been passed, but the same has been violated and
by erecting a shed in the property. And both the parties were directed to maintain status. The order is page 16. Page 17 is the operation.
Let the counsel for the respondent seeks 2 weeks time for filing counter. Post 24/11.
Item 68. Yeah,
Please.
Yes.
Order dated 2nd August 2022, directing the survey and demarcation of land has not been complied. Order is at page 91, paragraph 8.
Notice served.
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 Notice have been served.
So notice is served. No appearance is entered nor any counter affidavit is filed. You are taking notice?
Yes.
However, for an AGP for revenue, sought 2 weeks time for getting in for filing counter. Post time 24/11 for filing counter.
Item 69. KV Superready.
Please.
Next. First date is 28/2020.
And soon.
Written answer.
Means officer is transferred.
Page number 11.
Read the present collector.
The direction for the one that was established. This collector for having
Next week or 2 weeks?
1 week.
Don't file it on that day. You should file it in advance.
Tuesday.
17/11 for filing. To bring on record the necessary activities. Yes.
Item 70. G. Rajeshwara.
Yes. When? The instruction? Pardon?
Order is ready, but it is not approved.
What they say?
They should enter.
More presentation from the commissioner. 17 years.
Item 71. P. A. Kumar.
Notice out. What is the order?
Page number 11. Any further order, the respondent shall not show any activity which will result in submerger of the petitioner's land to the subject survey.
Need to pay attention. Just from 24/11. Filing counter. Family.
72. Rajeshwara Reddy. This is the final order dated 31/10/2022. Payment of compensation. Second respondent has to make. Taken land and it is forcefully, the collector of his transaction, collector of his. If or no payment is made.
What is the order?
Page 21, the lordship's order. Directing the second respondent to to examine the same in as ordered. The land which was taken in the survey number so into extent of land.
Yes, GPL. This is for compensation, but district collector was directed.
Yes.
This is representation for compensation. Maybe revenue only. Get instruction. Let them get, it's only consider. Amman is the rejection order వచ్చేస్తుంది. Next week, get instructions.
Okay.
Yes.
Item 73, MS Super 60.
They had child counted in the matter of production.
Yes.
And they allowed a submission.
You are ready? You want time?
And submission to you.
Yes.
This is an order where my lord has directed for consideration of representation within 4 weeks period of time. My lords, the respondent number 2 did not consider within 4 weeks of time, and on more than 3 occasions, she has written letters to the petitioner hearing. My lords, firstly, that the office of the district registrar cannot scrutiny an alternate record without the name of Christian Medical Education Society, and she has raised questions of fraud, whereas those questions of fraud and forgery were answered by the.
Any orders passed or no orders are passed?
No orders are passed, but she did not comply with the High Court order. She has only tendered an unconditional apology even in the counter with the same responses.
Yes, GB.
They claim to say that the file with the petitioner society name is not dropped at their office, even though this High Court orders are very clear that in the very year 2004 itself, those files were to be put back into the office of the district registrar.
Page 13.
Yes.
Proceedings, I may be permitted to check your alerts. I might have put it. 26(8) proceedings are put in your alerts, page 13 to 15. In this matter, she has even received communication from the IG office asking to comply in accordance with the Act and rules thereto and file a report. They state that they have retained the name Buddha Academy in their records as my petitioner society file is not with them, that is continuous. And therefore they cannot give me my own certified copies.
Okay, next week. Post 24/11.
Item 74, K. Ramakrishnan.
In this matter, there's a file counter stating that the date of hearing is fixed on 18th November 2023. With regard to the grant of the ORC certificate to the petitioner hearing, the petition was disclosed.
What is the date? 23/11.
18/11.
Counter filed by the respondents stating that the date of hearing for considering the claim the petitioner is fixed as 18/11. For reporting complaints. 8/12 for reporting complaints.
Item 75, K. Panibhushan.
Purchase of legal to suspend the implement order where the temple was exempted from the purview of the endowments department. Immediately, I had made a representation that Lordship's order is 16/9. I made representation on 23. Pursuant to the same minute, Lordship may kindly consider this counter filed by the third respondent for amendment.
What is the violation?
Addition, my lord, they have to undertake the temple again into the Department of Endowments. They have to appoint the executive officer for administration of the temple. Lordship may kindly see page 12, my lord, pursuant to the Lordship's counter filed by the respondent.
No, let's see allegation in your affidavit first.
Yes. How specifically stated? I read paragraph.
Yes.
It is respectfully submitted that matter the petitioner has submitted a representation for the second respondent, who is competent authority to take appropriate action in appointing the executive officer to the subject temple on 23/2023, duly bringing the interim order of this honorable court dated 16/3/2023, WP number 7221 of 23, and requested him to appoint the executive officer to the subject temple for better administration of the institute. But second respondent, who is also having the charge of the first respondent, have not taken any steps for the implementation of the order of this honorable court, as well as the request of the petitioner. They submitted that petitioner had representations so and so, so and so. Of the second respondent. It is submitted despite of the above interim orders, the second respondent willful disobedience. The same has been substantiated by the material paper appended by the.
No, what is the effect of interim order suspension?
Lordship may kindly say, I have appended the GO also, Miller. Kindly consider page number, Miller. Page 31. Sorry, no, 30. Page 13. The exercise of the powers conferred by section 158, the Hindu Religious Charitable and Hindu Religious Institution and Endowment Act 1987. The government of Telangana hereby exempt the Sai Rama Temple, Korupra, Jagityal district from the operation of all the provisions of this act until further orders from the date of issue of this order. Once temple is exempted, Lordships are free to suspend this order. So they have to restore the things by appointing the executive officer for administration.
Yes.
But he has not done. In the March itself, we have represented and I have issued the legal notice immediately thereafter. That same service.
Yes. What is your counter?
Now, 611, the issue to my counter. 611, counter of the second restaurant. Commissioner has issued a proceeding on 611, appointing, making in charge arrangements of the nearby temple EO as executive officer of the subject temple. But Lordship may kindly consider from March onward, he is not in, it is not a case, he is not the notice, he is not in the notice of this order as well as my representation. But the implemented, when the contempt notices have been received, then only they have taken the action.
Yes. How they have complied with?
Yes. The delay aspect, Lordship, I kindly consider. To that extent, I am bringing to the Lordship's stand.
Strictly.
Even on a suitable temple, my lords, even there is no submission.
More than 1 crore income, my friend cannot say this.
This contempt case is filed alleging violation of the interim order passed by this court in WP number 7221 of 2023 dated 16th March 2023. In response to the notice issued by this court, the respondent number 2 filed a counter affidavit stating that the respondent stating that already duty officer was appointed for the temple education by duly making in charge elements by issuing proceedings RC number A2/9027 of 2023 dated 6/11/2023, and a copy of the same is also
Till 76, Mehboob Hussain.
Yes.
This has been approved for the 5 groups of studies.
Notice to serve in the notice. When was it served?
I have filed the online track.
6/11.
Thank you.
Where is the track report? Track report is not here.
My two members.
Report in the shoulder.
Yes.
Yes. Notice. Yeah, it's filed. From the postal track report, it is noticed that notice is served upon the respondent on 6/11. No, it is. Then no extension.
Requesting for 1 week only.
Yes. Request of land council for the petitioner. When
1 week.
Question 17. Yes.
Intermart may be extended till then.
Next week we'll see. It's there till then.
Till then.
Yes.
Item 78, deletion of the number.
Yes.
more respondents or respondents. Maybe. First round. Respond.
Ravikiran Garu, yes, your assistance is required. I disposed of the writ petition. In fact, this is MS Ramchandra Garu disposed of the writ petition. Then it went in writ appeal. Their division bench found that the learned single judge having taken note of the stand of that appellant and disposed of the writ petition without impleading that party as respondent, without putting that party on notice. So it was remanded back. Again, I disposed of the matter. In the meanwhile, some more implead applications were filed. I said it is for them to work out their remedies. They cannot come on record in this writ petition. And against my order, writ appeal was filed. Writ appeal was dismissed by one of the parties. And then the matter went to Supreme Court. Any stay granted there? SLP notice was ordered. Any stay granted there? Status quo was granted by the Supreme Court. In the meanwhile, one of the person who wanted to come on record in the writ petition, and where I dismissed the implead application, he filed writ appeal. And the division bench again set aside my order and sent it back for fresh disposal. Now my order is confirmed by one division bench. Matter is sub judice before Supreme Court. And can I again dispose of, consider the writ petition on merits or?
Till the decision is taken by Supreme Court, I cannot take. Because the subject matter is the same.
Yes, yes.
But you also cannot take a different view based on the implement party.
No, implead party was before me. I gave dismissed.
You also cannot decide the same issue once.
Again, I have to decide the writ petition.
Decide the petition.
And this was confirmed by one division bench already.
Will the disposal of the Supreme Court, unless it is clarified by Supreme Court,
See,
he is now because he must be right also. And that may be a most plausible and possible view. There is no doubt about it. Question is, my lord, is an order passed by the division. And requesting your lordships to clear the matter and clear argument must. Maybe that lord, your lordships have taken a view in the earlier case. It is saying that lord, unless the parties other than the petitioner work out their remedies before the revenue officials, they cannot object to a consequential
proceedings. No, this, a 5-year order was passed. Regularization order was passed. That order has become final. Writ petition is filed seeking implementation of that order. All third parties and come and say, and that order is wrong. And without questioning that order.
In fact, it was also confirmed in a revision, in a suo motu revision.
Yes.
That order.
That can't be done.
But
regularization order was confirmed in a revision.
Yes, yes. And in case if somebody questions that order, I can go into validity of that order. This court can go into, but nobody questioned that order. Everybody wants to resist implementation of that order.
They have already questioned the order. This is what I'm trying to say. They have questioned it. They don't pursue it there. No, they have questioned and it is pending before the authority. They don't pursue it.
Any stay granted there?
No, no. No stay granted. But when stay is granted, they don't pursue it. They are pending before the authority. Then also.
And the suit filed by you making a claim over the property was dismissed.
No, no. There is no suit. Property belongs to me. I did not file any suit for claiming it.
You didn't file any suit.
No, he filed a suit.
You filed a suit, you lost the suit, you filed appeal.
It's an arbitration suit between the family members.
True.
It is only a suit is dismissed. And
Dismissed, you filed appeal.
permanent appeal. The dismissal of suit doesn't happen in partition 1 minute. Partition suit doesn't decide the title of the property. The owner, it is between the family members. Dismissal of the partition suit for the very same property. Partition suit was dismissed. Before the land reforms tribunal, Lord, it was said saying that this property is the property of his junior paternal uncle. And in urban land ceiling also it was stated saying that this property is that of the junior paternal uncle. So all the proceedings do not give understand submissions is contrary to the record. Then I'll show Lord if your lordships are inclined.
They order the appeal orders.
I'm giving the order.
I'll post it on Monday. Tuesday we'll have it.
I also filed a petition for the Supreme Court in the XLC. If he has approached already Supreme Court, then he will not continue here, will not the complete application, or not can he challenge the order implementation of the order in my.
Better you file a review in writ appeal then. He has already filed implead there, and that's what he also wanted to do here.
He did not bring it to the notice of the Senate judge. But there he filed the Senate division bench. That he filed a instead of my writ appeal, I have filed before the Supreme Court. After allowing my application from my writ appeal. Your lordship post on Monday. In the meantime, Lord, I'll just see whether my clients will be file a review. Still not IA is also not member of the Supreme Court. Just on this Monday I have filed.
No, but still I have my own doubts whether I can pass again an order which is already confirmed.
Your lordships are, I was also pondering over that. But I also felt that Lord, hearing becomes an empty formality because your lordships have to take the very same view which your lordships took in the main writ petition. And all that your lordships may have to do is allow the writ petition saying that, and in the case Lord which went to Supreme Court, your lordships categorically held. Can I just take your lordships to the one submission in the 1 second? But your lordships may take the order copy, your lordships order. Only my increased application is dismissed by second honorable court. My arguments were not heard and my court is also not taken into consideration. So that means the lordship has opportunity to give me a chance of hearing and decide the issue fresh because it is not decided earlier. So
No, can this court go examine your case and say whether you have title or you have no title, or your title is better title or their title is better title?
Question of title. Whether the regularization done is without jurisdiction or with jurisdiction.
Did you question the regularization? Where is this writ petition?
In the writ petition, it is an incomplete application only dismissed.
Any stay against that regularization proceedings?
No, no. In fact, it was confirmed by a review and mirror. The prima facie, the regularization itself is very illegal and it is done without jurisdiction by the Tahsildar. It is a proceedings against a dead person. Fazilak Hussain, who has executed the dead on the set date of regularization. So, basically, just read your lordship's earlier order. Your lordship said all the contentions stated by the London Council for the respondent number 62 are in Supreme Court. Or in the absence of specific provisions in the statutory proceedings issued under Section 5 of the Act 1971, the said proceedings cannot be set. It's not in the present petition filed by the petitioners herein at the instance of respondent number 6. The contention of the London Council for the respondent number 6 that land in question ceased to be agricultural land by facing the claims of the judgment. The said finding was recorded in the year 2009. But the proceedings under Section 5 of the Act 1971 in favor of petitioners were issued as of the as in 1995. And further development also as said in paragraph 77. It is also clarified by way of evidence caution that observations made or for the purpose of this case, they shall not be considered as making any comments or giving any findings on the merits or demerits of the case. The authority sports shall deal with the cases on its own merits, uninfluenced by the observations and findings recorded here. Hence, the third content also deserves no consideration. Further, respondent number 6 itself approves taking detail of its name under the provisions of 1971. And your lordship may have to adopt the very same reasoning about my rent fund. Your lordship said,
After giving me an opportunity.
alright, maybe after giving him the opportunity, your lordship may have to record as your lordships have recorded a finding not in respect of respondents.
Unless, my lord, your lordship was pointed, unless 5-year regularized proceedings are questioned, my lord, he will not have the saying this.
No, I have given reasons for while dealing with the case of respondent number 6. Same, I said same thing applies to these people also. Because every, for the same reason I need not give for all the.
For all this order. Monday, your lordship.
Tuesday.
Tuesday.
3 weeks time may be granted so that I will file a detailed counter also. So that then it can be heard for whatever makes it.
So he has filed counter affidavit.
This is not considered by the time.
Yes, filed counter affidavit now.
Yes, but it's not considered by this.
Then must counter affidavit take.
If I am wrong in not considering that, that can be considered now.
Okay.
If permissible.
Tuesday.
3 weeks time. I will be. They post it next Thursday. Meanwhile, you also see what is to be done. And
Next Thursday.
Item 79, MB Krishna Mohan.
The back to represent our case in 2011. So last occasion, the people land acquisition taking time for us, sometimes counter problems.
Why 1910 we granted you time. In fact, from 8 to 23. And what ground you are questioning? Objections, sir. What is the stage? No, what is the status of the lands? Pardon? What is the difficulty? Why from February 23 onwards? When finally? Time and again, the matter was adjourned for filing counter. Quite a same. Finally 4 weeks time for filing counter. From 8/1/2023 for filing counter. If the counter affidavit is not filed by the date, the respondent number 3 will appear before this court in person. 8/12 conditional order.
Item 80, D. Ambedkar.
Yes, GPRO counter. Learned government leader for land acquisition submits that written instructions are already received and seeks time for filing counter. Post on 9/11.
This decision has been paid to your requested your last time for two
Yes.
elections. We are
Okay, finally. When?
3 weeks.
4 weeks, 8, 12, same order. R3 shall appear. R3 shall appear, failing which 8, 12.
Yes.
Vacant land. There is no need of
Pardon?
application. In the vacant land.
Let them file first.
Item 81 and 82.
Progress.
Yes. Counter file?
Yes.
Instructions for study. Land and fees for effort. No one land is a consent award is given. Fees we are start reference on. What it is.
Counter ఇస్తారండి.
The consent was just, and this endorsement has been passed.
This thing refers only to this plan. They're not seeking reference. Well, already consent for the land.
Next matter only.
Great award also is possible. Next matter. What is allowing that a short time in that application.
Award has been passed on the officially that form 3 and form 4 has been signed. The case has been deferred and the supplementary award has been passed. We say by passing an endorsement is that as a consent award, form 3 and form 4 has been signed originally, hence the same thing applies to this supplementary award also, hence they are not entitled for reference under section 18.
Why it was deferred then for while passing the award?
Valuation, correct valuation.
If valuation itself is not aware, when the question of consent. Why was it deferred in the original award?
What number 44 and 45?
23 rejection. Night 2431.
What question dated 6/5/2011?
Yes. Where they say it is deferred for in respect of trees. Anything, any such observation? Trees valuation is shown as 0. Deal.
Probably covered by the judgment of honorable court in that judgment also.
Page? This is Aksumarity.
Yes, sir. 1890. Page 1890.
same project and same purpose.
Yes, GPR, application is within time. Then same order. You please give those dates. The date of notification, declaration date, and award date. Whatever the dates mentioned in the first paragraph of this necessary disorder. Give the dates on a slip of paper to the courtmaster. So page 18 whatever dates is correct, dates is. Yes, what about the other one?
Can I give the dates? Everything in this.
Both are same award or
Same.
award is same?
Award is
Give the dates for this also.
yes.
Item 83.
I may be permitted to appear online, Your Lordship. And the matter has come up on the last occasion. They have taken time for instructions.
Yes.
When the matter has come up on the last occasion, the learned GP has taken time for instructions in this matter, Your Lordship. It's a land acquisition matter wherein they have acquired 306 square yards.
You served papers on land GP?
That was served, Your Lordship. That was served on the same day.
GPR and HMDA?
It was a GP, Your Lordship. A counter is also filed in the matter.
You filed counter?
If the counter is
Counter number. Last citation papers are served on you.
but the National Highways, the third respondent has filed counter in this, Your Lordship.
And counsel for the petitioner is directed to serve papers on land GP for land acquisition. In turn, GP for land acquisition shall get instructions in the matter. They say papers are served on you. 1910. Verify. Yes. It's true. To print the name of GP for land acquisition in the pass list and post on 16.
Obliged, Your Lordship.
Item 84, BB Ramnava.
Pardon?
Application. Economic sector, but my name is not from such I am entitled, I may discuss family.
On what ground you are not you are denied?
That I was married and I was living in settling up village.
You filed any reply?
I filed a reply. You know, I filed the
Don't reply. When you filed it?
certificate of. I didn't.
When you filed reply?
On 30th now. 30th.
Clear.
Office to verify and put up the reply would be filed by the ESR number. Final state of meeting. 16th for orders.
Item 85 takes away.
May please, Your Lordship. This writ is filed, my lord, challenging the action of the respondents, my lord, in not dispersing the amount, my lord, though the award is passed in favor of the petitioner, my lord. Petitioner's land, my lord, required for the purpose of extending the road, my lord, national highway. Thereafter, my lord, award is passed, my lord. Page 18, my lord, is the copy of the award.
Yes.
Page 19, my lord, where the petitioner is arrived as the awardee, my lord. Third from the bottom, my lord. Survey number 115/2, page 19. Survey number 115/2, Perala Ramakrishna, son of Rajamouli, is the petitioner.
Yes.
And the award says, my lord, 7,82,347 rupees is payable to the petitioner.
Counter filed.
Counter filed by the endowment department, my lord. What happened was, my lord, endowment department took an objection, my lord. So the land acquisition officer, complaint officer, stopped payment. My lord.
What is the date of award?
2015, my lord.
Where is the award?
Page 18. Award starts from page 18.
Not the award. There is some tabular. Is this the award? Yeah, statement sheet. Where is the award proceeding?
That is only filed, my lord. Page 18.
What is the date of this award?
And there's a reference of award, my lord. Award number 2 of 2015 in file number. Date is not mentioned in.
Yes. What's your stand? Any proceedings issued by LAO stopping the payment?
No, my lord, no proceedings are issued.
What is the stand of endowment department?
Endowment says, my lord, it is their land that they have transferred it, assigned it to some temple, my lord, Hanuman temple. They did not file any material, my lord.
We'll send it to the other authority. He should have sent it. Why you? Because award date also not there. Refer it to the authority.
But I'll verify, my lord. Lordship may post next week, my lord. I'll verify.
Endowment said anything about award in the counter?
They're simply saying, my lord, it is the land belongs to Hanuman temple, so nobody can claim compensation.
You received any instructions?
No.
Give the award date. I'll refer it to the authority.
Alright. Tuesday, my lord, I'll verify. That should post Tuesday.
No, shall I refer it to the authority for adjudicating the travel claims?
Yes.
But award already passed in the name of petitioner.
Yes, my lord.
Anyway, we cannot adjudicate that issue here. And endowment department didn't take any steps till now.
Yes.
Yes, my lord. During the process, they did not take any step, my lord, to object or interfere. After the award is passed, they
Yes, third council for petition. No representation for respondent. For post for others on Tuesday. Tuesday for others, you ascertain the date and other things.
yes, I'll listen.
Item 86, Anumurthy Bala.
In this case, the land acquisition officer has filed the counter, but no record is transferred. Copy is not supplied. Whether it needs any reply or not, we have to accept it.
Pardon?
Whether it needs any reply or not, we have to accept it. But the real dispute is within the 10 kilometers of municipal area, the national highways proposal for toll booth, and that is a violation of.
You already filed reply.
There are two counters, Mayor. One is from National Highways and one is from, just now I received it. Respondent number 5. Next week, Mayor, for reply and all.
Whose counter it is now?
Pardon?
Who filed counter today?
Respondent number 5.
Yes, respondent number 5.
They gave a copy. Already.
You are bouncing for the petitioner. Please stand to be
Not just
reply.
it's no problem.
It's 23rd.
Item 87. Wait.
So here, all the water body matters are before the honorable court. The court, so it has to be attached with the bill 125. So all the water body matters, that is with regard to the not making any constructions in the water bodies. With regard to this is, but I am owning a land, but not adjacent to the tank. Now they say it is coming under FTA. In fact, RDO has also passed an order converting the non-agriculture to agriculture. When they cancelled, I questioned before this honorable court and this honorable court allowed. And also filed a writ petition not to interfere with my possession and journey. Both are pending. The rights, they don't allow me to do any agriculture operation. And they completely said that it is coming under FTA. They don't acquire. I said, if you acquire or give any alternative land, you know, they can't destroy. It's a private pata land, they themselves have made. There's a Shikam pata. It's not a Shikam pata, it's a private pata land. And I mean, my vendor was in possession of the property. I purchased it from him. And my contention is that if they want to deprive my property, pay compensation, or alternatively, you give some other land, a suitable land in lieu of that land. They don't do it, man. Your assets are aware, man, several judgments are there. Even a division bench of this honorable court, with regard by dealing with the Hyderabad water bodies, sets up, you fix a water body level, FTL level, and if it comes under the FTL, then you pay the compensation to the parties. That also, on the last occasion, it came up before the lordships also earlier. Before one of the learned single judges, we argued at length, because of the change of the roster, again, address.
In fact, one of, and Tahsildar also recommended Malad for acquisition of this property for public purpose. And in the irrigation department, people says whenever a public purpose is there, we will ask. But they are depriving the property, Malad, even though Malad, I got it converted into non-agriculture purpose, even though it is a private pata land. But that is the
What is improved in 10/2018? 3/11/20.
yes, Malad. Improved order is they say you can, whenever the water recedes, you can. That is the page 14, Malad. First is an order passed by this honorable court in a writ petition. Consider my representation either through acquire or through alternate plan. But page 14, that is 3/11/2018. The representation received something that the orders have been passed by the Honorable High Court of Education at Hyderabad, Court of the Petition, with the direction to consider the representation and part of the petition from the date of receipt. In this regard, it has been requested to Superintending Engineer INCADT, IB Division Nizamabad by reference to under in fact Patala, it is the underside in respect of Patala in survey number for the show. To and file the petition immediately before the competent authority for additional session with the FTL authority in order to comply with the order passed by the honorable letter. In this connection, on perusal of the copy of the letter received by this office on the letter of Superintending Engineer so and so, Revenue Divisional Office set about has been opined as follows. The survey number 203 is coming under FTL Mallaredi Cheru, and the said land which is not used for public purpose at present. The conversion of land from agriculture to residential purpose for low-lying out house plots by filing and leveling of the FTL tank is impermissible under law. Due to this, tank efficiency will be reduced. Any haircut will be affected. The Mallaredi tank was constructed before independence of India, and Nizam Sagar project cannot sub-distribute so and so. At present, there is no need to acquire the land for the public purpose by irrigation department. The Honorable High Court in writ petition so and so. This is another writ petition, Malad, where this Honorable Court stated grantee of Shikampata. Where in Shikampata is there, Malad, then they can cultivate the land as and when water recedes. The land is entitled to enjoy the same by cultivating when the FTL level are low and there is no water. On verification of the revenue records as per Kastra Pahani so and so, the land in survey number 230, total extent 3 acres 0.1 Kunta, 60 Armour village is classified as Patta land and continued in subsequent Pahanis to till date. On field inspection, it is revealed that said land comes under the FTL of Mallaredi Cheru of Armour village. In view of the above circumstance, the representation cannot be considered. And the Tahsildar also passes the same order, Malad. We also accept Malad on verification of the revenue record from 1954-55. Next to page 17. It is a Patta land. 54-55 onwards, it is a Patta land. You never said Malad, it is a coming under FTL at any point of time. Even Irrigation Act provisions also says it is useful for public purpose. But then they have to strike this land.
They file counter.
They file counter, Malad.
What they say?
Same as it is coming under FTL, and then when it's required, they'll.
What is the basis to say that it is coming under FTL?
No, there is no basis. They say it is coming under FTL according to their survey report. And in one of the reports, Malad, the Tahsildar has also stated that this is land is required for public purpose. You acquire.
What is the survey number?
Survey number is 230. Total extent 3.01. Actually, Kunta is 229, but this is in 230.
ASGBF.
A photograph filed by kindly peruse the photograph. The road is also intervening. It is there, madam. Clearly shows that a water body is there. They have filed a 4 to 5 photographs. Page 126 is the photograph, madam. You have to see that. Yes, they are also marked, madam, survey number 229. Road is intervening. My land is this side.
This appears to be not part of the tank.
Not part of the tank. And road survey also lengthy, madam.
In between tank and this to survey number 230, there is.
230 squeeze is there.
30 lo kada, 229 lo adi. That is 229.
That is 220.
230 is on the extreme right.
Yes. And the houses are also visible, you know, I can listen some houses are also.
And you admit that there is a road in between. Survey number 229, 230 also.
Yes. And I am not objecting for acquisition, but if they want, they can acquire. You know that some land may be given, but they can't deprive, they can't. Well, I can't cultivate also. You know, they can't see road is intervening. They themselves lay the road. If it is a water body, they can't lay the road for copy purpose.
Yes.
So, if you will argue, they will say.
You argued. Over engaged.
Time may be granted.
For orders on Monday.
So, Monday is order.
Tuesday. Yes.
Committee, T. Rajalakshmi.
Fraction of respondent of the artist is not saying the compensated amount for executing the plan.
Counter file.
Last occasion, they have to send for fighting contest.
Any document file to show your title?
Page number 16.
Shall I dispose of directing consideration of your representation? Shall I direct them to consider your representation? These are the petitioners. Who is second petitioner?
The other one.
Representations refer to your extent only. Then second petitioner, any representation? You didn't even say who is the second petitioner also. Who is appearing for R6? It's the case of the petitioner. Possessor of an extent of clear to survey number 93 by 17. Out of total extent of 3 acres, 3 gunters. He has been in possession and enjoyment of the said property for the past 50 years. The portion to the said extent of said 1 acre 2 gunters was taken over for the purpose of construction of canal of Devadula project. An extent of 37 gunters was affected in the said canal construction. However, without paying any compensation. For those circumstances, petitioner claimed to have submitted application dated B7/2018, 27/8/2018, before the respondents seeking for payment of compensation. So, as a representations are still pending for consideration before the respondents, and hence petitioner approached this court by filing the pending paper. Please contact the comments. They may know that is not inspect the respondents. This court is of the considerable that it will allow the respondents at the first instance to consider the claim of the petitioners for payment of compensation in respect to the subject area. The petition is disposed of. Detailed representation. Is right for payment of their right for payment of compensation. In respect of land administering 37 meters situated in survey for 93 by 70 of Alnapur village, Kumaragalli Mandal, Siddipeta district. Respondent number 2.